Item 23.
May I please? Yes. We have the appellant is convicted under section 302 and other three accused persons are acquitted. And case based on the evidence of PW9 and PW15. Allegation that he has used the Ghodisha. First he has hit on the head, then his abdomen.
The right to private defense.
Evidence come up that the deceased first attacked with a lathi, for which he has sustained and examined by the PW1. And two injuries was to the appellant. The prosecution has not suppressed that informant did not say about that, but the other witness who was believed by the prosecution had mentioned in para 5 that this
এটা টিকে মাল right supraclavicular right RIUST. Supra SUPRA clavicular enter. Precaution. Right on the airport side on this one. It may be one blow, it may be two blow, because if that falls on the head and sleeps also, then it can cause both the injury also. That the first one is on the skull, on the vertex, and the second one is on the right supraclavicular region. So now, except your submission that the injuries are not possible because it was a sharp edged weapon, and the injury that has been caused The one is on the is a lacerated wound, the other is a punctured stab wound.
Yes.
But the doctor who examined that weapon of offense,
Yes.
when opinion was sought for, he has examined it and gave his opinion that it is possible.
Yes.
And that evidence has almost remained on second.
Yes.
The evidence of the doctor and of course the two eyewitnesses version, if compared to each other, one eyewitness has implicated four persons, whereas that is PW 9, but PW 5 has only implicated one person in the assault.
Yes.
That is this appellant.
Yes, ma'am.
And the doctor also did not find any corresponding injury to the assault of those three persons. And that is the reason why the London trial court disbelieved the participation of the three co-accused persons who faced trial. But the who has stated out of the prosecution witnesses, who has stated about the assault on this appellant by the deceased? Who are those witnesses?
PW10.
Assault on appellant by deceased. And PW10 is the only witness.
Yes.
He turned hostile, Millard. At
No, hostile means he in the
chief, he admitted that the deceased assaulted the appellant first. Then
previous statement was confronted where he has stated that after the assault was made, but assault part is there.
Yes.
In both the, maybe in the 161 or in the court statement, the assault by the deceased to the appellant is there. And
Also PW15 his cross-examination.
PW15.
Eyewitness.
That is an eyewitness.
Page 92.
Yes.
Para 5. I stated before the police that the deceased Ananda, having arrived at the spot, assaulted Chittaranja by a lathi held by him. I also stated before the magistrate. 15 days after the incident, police called me to the PS, and from there I went to Digapandi to depose before the magistrate.
So that means this was the first statement. Now he has given it to a go by. He has stated that now in the court statement, PW15 has stated that you read that portion.
At that time, Anand Naik, the deceased. The complainant
and one
and Vasanta shouted, quarreled in front of the house of Nakula Naik of my village. Hence, Nakula Naik, father of Vasanta, came there and caught hold of Pramod Naik. At that time, accused
Chitra means this present appellant.
Prabhasi, Bhaskara and Kalyasa.
They have been acquitted.
Yes.
Yes.
Assaulted Pramod.
Pramod is PW9.
Yes. On our protest, they shouted with us and dispersed. Half an hour thereafter, in front of the house of Vishwanath, again the accused person picked up quarrel with the complainant. At that time, Anand Naik, the
complainant is PW9. 9, right?
Yes. At that time, Anand Naik, the deceased father of Pramod, came there, but accused Chitra dealt a blow on the head of deceased Ananda by a ghodisha and thereafter pierced the ghodisha on his belly. As such, Anand Naik died at the spot.
So what his statement is that this at that time Ananda Naik, the deceased, came there. Say tapare se koitla, and perhaps that he assaulted the appellant
Directly.
with a lathi.
Hmm.
Say not only in the 161 but also in the 164 statement. Mr. Tripathi,
Yes, ma'am.
সেই পার্টটাକୁ ଇଏ deliberately omit କରୁଛି।
164 omit କରିଛି ତବେ ଏଥିରେ
ନାଇଁ ନାଇଁ 164 ରେ
କହିଛି ନା
164 ରେ କହିଛି 161 ରେ ବି କହିଛି। ଏଇ ଯୋଉ ପ୍ରଥମେ ଆଉ ଥରେ ଆପଣ 5 ପାରାଗ୍ରାଫ ପଳେଇ ଆସନ୍ତୁ ଯୋଉଟା ସେ ପ୍ରଥମେ ପ୍ଲେସ୍ କଲେ। I have stated before the police that the deceased Ananda, having arrived at the spot, assaulted
Chitrasen.
Chitrasen is the appellant.
Yes.
ହେଲା
by a
by
lathi.
a lathi hold by him এবং ପୁଣି admit କରୁଛି I have also stated so before police। ତା ମାନେ ডিসিজ যেତେବେଳେ ଆସିଲା ସିଏ ପ୍ରଥମେ ଆଗେ appellant କୁ ମାରଲା
Yes.
ଲାଠିରେ ତାପରେ ଏଇ ଯୋଉ
retaliate
କଲା
appellant.
appellant, and appellant has given 2 blows according to this both the witnesses. One is on the head, the other is on the
belly.
belly. That was a piercing stab wound ମଧ୍ୟ ଅଛି।
Stab wound
That's
ଅଛି।
all. So your witnesses, 2 eyewitnesses, can they be said to be absolutely reliable? Because 3 categories of witnesses has been they is absolutely reliable, no corroboration necessary, absolutely unreliable, it has to be totally discarded. If it is partly reliable and partly unreliable, then corroboration in the material particulars is to be sought for. It may be from the PM report, it may be from other sources. So now if we analyze the evidence of that first witness, eyewitness PW9,
9.
he has implicated 3 co-accused persons
Yes.
in the assault, which has been disbelieved by the London trial court because of the fact the corresponding injuries are not there. Right? This appellant, the PW9.
Yes.
PW9 kohuni ki mane?
Yes, yes.
Okay. So, and his evidence is totally silent, of course, that the deceased assaulted the appellant. Now, if you come to the evidence of the other eyewitness, 15, his evidence is, of course, silent about the participation of those 3 co-accused persons who are acquitted.
Yes.
Not only that, whatever he has stated before the magistrate as well as in the 161 statement before the IO, that the deceased first came and assaulted the appellant, that part he is deliberately omitting. So in that way, can it come that with these 2 witnesses, can they come within the that absolutely reliable?
Yes,
if absolutely reliable nuhe, then partly reliable or partly unreliable, which is getting corroboration from the medical evidence. Now the thing is that if he came, he was not a party to the quarrel. He came and started assault. Okay, 2 blows have been given, and it is a vital part of the body, head re ଦେଇଛି ଆଉ ଗୋଟେ part ଅଛି। Whatever he has given, as we pointed out the other day, maybe that he has exceeded the right of private defense, but can it be a case under section 302? Because those 3 cases we saw in that day, they say that where the case is that private right of private defense has been exceeded, then it would be a case under section 304 part 1.
Yes, ma'am. That statement of PW 15, madam. That I am reading. There is previous quarrel. That I am reading.
ଗୋଟେ quarrel ଶୁଣନ୍ତୁ, ଗୋଟେ quarrel ଆଗରୁ
ହେଇଯାଇଛି। That is half an hour after, that is continuing.
ସିଏ ଅଲଗା ଲୋକ, ଆପଣ ଦେଖନ୍ତୁ ଆଉ ଥରେ ପଢୁନାହାନ୍ତି ଆପଣ ସେଇ ଯୋଉ ଦେଖନ୍ତୁ
at that time the
ଆପଣ
complainant and one
15 ପଢୁଛନ୍ତି ତ?
yes
PW 15 now 1, 2, 3, 4, 5, 6. 6 line ରୁ ଆରମ୍ଭ କରୁଛନ୍ତି ଆରମ୍ଭ କରନ୍ତୁ.
Yes, at that time,
Hmm.
accused Chitra, Prabhasi, Bhaskara, Kailaso assaulted Pramoda. Pramoda
Okay.
means that informant.
PW 9 pra?
Yes.
Huh.
On our protest, they shouted with us and dispersed.
Huh.
Half hour ଏମାନେ ସବୁ ଫାଷ୍ଟ ଝଗଡା କରୁଥିଲେ ତାପରେ half hour after thereafter in front of the house of Vishwanath again the accused person picked up quarrel with the complainant.
ତ
at that time
ମାନେ କଳିଟା କାହା ସାଙ୍ଗରେ ରହୁଛି ଆମେ କହିବା କଥା
ପ୍ରମୋଦ ସାଙ୍ଗରେ ହଉଥିଲା
କଳିଟା ଇଏ ଡିସିଜ ସାଙ୍ଗରେ କେବେ ଆଗରୁ କିଛି ନାହିଁ.
Who is the deceased? Deceased is the father of that Pramoda.
but
yes, when his son is quarreling and has been beaten, a father can be resist.
ଓହୋ ମାନେ ଆପଣଙ୍କର କେବଳ କଳି ହଉଥିଲା
କଳି ହଉଥିଲା ବାଡିରେ ମୁଥା ମୁଥା ମରା ହେଇଥିଲା ସେ
କୋଉଠି
କହୁଛି
ଆପଣ ଆଗକୁ ପଳେଇ ଯାଉଛନ୍ତି ବହୁତ.
ନାଇଁ ନାଇଁ ସେଇଟା ତ PW9 କହିଛି ବାଡିଆ ବାଡି ହେଇଥିଲେ.
ତାପରେ ଯୋଉ ଆନନ୍ଦ ଆସିଲା ଯାହା ବି ହଉ at least there is no material that any weapon was used.
No weapon was
right.
No, yes.
So if there was any quarrel between these 4 accused persons, let us accept that.
Yes.
4 accused persons and PW9.
Yes.
So at that time this Ananda Naik, okay,
yes,
the deceased Anand Naik deceased to?
Yes.
Anand Naik.
Right. Yes. Anand Naik deceased, the father of Pramod.
Came there.
Means PW9.
Yes.
Right. So he came there. Then
that is
no ଆପଣ ସେ ରହି ଯାଉଛନ୍ତି ନା ସେଇଟା ହଉଛି ଅସଲ କଥା ଆଉ
first assaulted this Ananda first assaulted Chitra the appellant.
ସେଇଠି ତ କଥା ଅଛି ଆଉ
why when they saw his son was beaten up then a father can be resist.
No
he came to rescue that his son.
Where is that
that is not there.
Where is the that injury report of PW9?
PW9 PW2
no PW9 where is that? PW9 ର କିଛି injury ଅଛି?
PW2 ଟା ହଉଛି ପରା
postmortem ସେ
yes
PW9 ର କିଛି injury ନାହିଁ.
ଆପଣ କହିଲେ ବାଡି ପକେଇଲେ ତାକୁ ମୁଁ ସେ
କହୁଛି three fist blows was given on his nose. Yes. But there is no injury, nothing is there.
It is not available.
3 blows were given to him.
No PW ଆଉ କି ନାହାନ୍ତି DT ଡକ୍ଟର ଆପଣ ଏକ୍ସାମିନ କରିଛନ୍ତି ଗୋଟେ ଏକ୍ସାମିନ କରିଛନ୍ତି ଆପେଲାଣ୍ଟ କୁ ଆଉ ଗୋଟେ ଏକ୍ସାମିନ କରି ଆଉ ଗୋଟେ PM କରିଛନ୍ତି ବାସ୍ ଦିଟା ଡକ୍ଟର.
See the statement is like this, all on a sudden accused Prabhasi Naik gave 2 to 3 fist blows on my nose. Thereafter the other 3 accused persons, namely Chitra Naik, Bhaskar Naik and Kailash Naik, surrounded me. At this juncture Ananda Naik has arrived. When his son was surrounded by these accused persons. So all through it has been the case that there was a quarrel, and the fist blows that is being stated here is not corroborated by medical evidence.
There is no medical evidence to the assault of PW9. Is it a fact or not? At least prosecution has done.
Yes.
Okay. So if there is no medical evidence, it is a case of simple quarrel between 2 parties, let us say. From in the one side you say that appellant was there and 3 co-accused persons were there, and in the other side informant PW9 was there. Right. At that point of time father came. So
he saw that this person is surrounding.
Nobody is armed with weapon.
Yes.
What he did, he came with a lathi, assaulted the deceased. Assaulted the appellant on the vital part of the body. Then whatever he has done, whether even if it can be said that he has exceeded it. Question is that whether it would be a case in such a situation if he has exceeded it, as you said, and provoked. Obviously, when you assaulted on somebody's head with a lathi, it is obviously that he would be provoked, and in that way, if he has dealt 2 blows,
and there are injuries.
Yes.
The manner, but injuries are there.
These three decisions which we cited,
Yes,
have you got any other decision? There are sabu ये जो तीनटा decision 91 Supreme Court 2003 2001. These are all the cases where the injuries are also not very serious on the otherwise they would have straightway right a private defense per char dina. जेहेतु ସେମାନେ होल्ड कले ना एटा सिंपल इंजुरीज बेली बट स्टिल देन दे वांट कहले जे तमे एक्सीड कले से एक्सेप्शन 1 को आनी किनी ताकू सब
304.
तीनटा केस रे 304 पार्ट 1 करछन एटा जून acute ले ये हबो depends upon the nature of injury please show कारण आपणकर प्राइवेट डिफेन्स कोठी स्टॉप हबो से कथा मध्य आईपीसी रे that has been laid down आपण कोठी डेथ करि परिबे कोठी आपणकर केति की ये परिबो of course it is not to be measured in golden scale but
the extent
extent आपण तीनटा बही मगेले दियंत अच्छा ये लिखि दउछि मगेले which decision you want to place first 2000
one
that Moti Singh
Yes.
okay first let us see what are the injuries sustained by the that appellant that is there in paragraph number 5 okay
Judge Singh found the following is one continued lacerated wound on scalp or
scalp hospital
region of the size half inch into 1/4 inch into 1/4 inch. One abrasion on left pinna of the size into 1/4 inch into 1/4 inch into 1/4 inch. One abrasion on the lower lip of the size 1/4 inch, 1/4 inch, 1/4 inch.
Read. Yes.
In spite of the above fact and situation, the High Court was not inclined to concede right of private defense to the appellant, mainly on two premises. One is the appellant did not put forth such a plea at all. The second is that injuries noted by the doctor on the fifth accused Jai Singh are minor wounds. Para 8.
7 point
Neither the said premises could be approved on fact and on the fact situation. The admitted case of the prosecution is that after the occurrence, witnesses and the deceased together went towards the house of the accused during the untimely hour on being told that one of them was attacked by the appellant and his brother a little earlier. The injuries sustained by Jai Singh give a clear indication that the prosecution party was armed with blunt objects. They have no case that the injuries found on appellant 5, Jai Singh, were inflicted only subsequent to the injuries which deceased sustained. In all probabilities, appellant 5, Jai Singh, would have sustained the injuries prior to the deceased received the fatal injury.
ଏଠି ତ ପୁରା ଅଛି evidence ଅଛି Yes. Next.
Can the appellant legitimately claim right of private decision in the above situation? The answer, in our opinion, is in the affirmative. Though the dimension of the injuries on appellant 5 Jai Singh cannot be regarded as very serious, the situs of them indicates that he was then in a dangerous situation. The depth of lacerated wound on the occipital region, injury on his lower lip, and one on his left pinna could possibly account for 3 different strikes inflicted on him with blunt objects. If such an attack was made on him by a crowd just in front of his house, the accused could reasonably entertain the apprehension that at least grievous hurt would be caused to them by the assaulters, unless the aggression is thwarted. Chapter 9, Section 102 of Indian Penal Code says that the right of private defense of the body commences as soon as reasonable apprehension of danger to the body arises from an attempt or even a threat to commit any offense, though the offense may not have committed, and the right continues as long as such apprehension of danger to the body continues. Section 100 of the Indian Penal Code confers the right of private defense of the body up to the voluntary causing death or any other harm to the assailant. If the offense which occasions the exercise of the right be of any of the acts as may reasonably cause the apprehension that previous hurt be the consequence of such assault. Para 10. Regarding the contention that the appellant is dissented to get the benefit of right of private defense as he failed to make out a plea in that regard, we may point out that it would be quite unjust to deny such a right to the accused merely on the ground that he adopted a different line of defense. If the evidence adduced by the prosecution would indicate that the accused were put under a situation where they could reasonably have apprehend grievous hurt even to one of them, it would be inequitable to deny the right of private defense to the accused merely on the ground that he has adopted a different plea during the trial. The crucial factor is not what the accused pleaded, but whether the accused had the cause to reasonably apprehend such Para 11. This court has stated above the legal position time and again. A three-judge bench of this court in state of Uttar Pradesh versus Lakshmi, the law is that burden of proving such an exception is on the accused, but the mere fact that the accused adopted another alternative defense during his examination under section 313 of the code without referring to the exception of section 300 of IPC is not enough to deny him of the benefit of the exception. If the court can call out materials from evidence pointing to the existence of circumstances leading to that exception, it is not the law that failure to set up such a defense would foreclose the right to rely on the exception once and for all. It is axiomatic that burden on the accused to prove any fact can be discharged either through defense evidence or even through prosecution evidence by showing a preponderance of probabilities. And 12. A two-judge bench of this court in Periyasamy and another versus state of Tamil Nadu has stated thus. We may point out that the appellants have not stated when examined under section 313 of the code that they have acted in exercise of such right. Of course, absence of such specific plea in the statement is not enough to denude them of the right if the same can be made out otherwise. Mr. S.S. Sindhe, Law and Counsel for the respondent, State of Maharashtra, invited our attention to the decision of two-judge bench of this court in Suresh Singh and others versus State of Haryana, and for supporting a contention that even if the accused had any initial right of private defense he has exceeded the said right in view of the disparity in seriousness of the injuries sustained by the accused vis-a-vis those sustained by the deceased. The said decision is the facts of the particular case and it cannot have any applicability in this case. Neither the injuries sustained by the accused nor even the absence of the injuries sustained by the accused would be, in certain situations, be sufficient enough to deny the right of private defense or the extent of that right to the accused. In our considered opinion, the appellant, even if the prosecution version that it was he who inflicted the fatal stab on the deceased is to be accepted as correct, it ended in the exercise of right of private defense, as the reasonable apprehension that the grievous hurt would have been inflicted to one of the accused cannot be ruled out. On the broad probabilities delineated by the prosecution to the evidence, we are disposed to extend the said right to this appellant. Resultantly, the conviction and sentence passed on him cannot be sustained. In the result, we allow this appeal and set aside the conviction and sentence passed on him by the trial court and affirmed by the High Court. We acquit him. We direct the appellant be released from jail forthwith unless he is required in any other case.
So, the right of private defense ho kimba in the case of rape consent plea ho, it need not be pleaded even.
Yes.
But if the court finds that the materials available on record is there that such plea can be availed by the accused, that can be also that benefit can the accused can get, that can be extended to the accused. So here you have taken that plea that ଆପଣଙ୍କର question number 9 ଟା 9 ଟା ଥିଲା ଯୋଉଟା page 51 ରେ ଅଛି ହଁ 9 ମିଛ କଥା ଆନନ୍ଦ ଆସି ମୋତେ that is page 51 ଆନନ୍ଦ ଆସି ମୋତେ ଆଗ ଠେଙ୍ଗାରେ ମୋ ମୁଣ୍ଡକୁ ମାରିଲା ମୁଁ ତଳେ ପଡିଗଲି ଯୋଉଟା କି PW 15 ମଧ୍ୟ ସେଇ କଥାଟା କହିଛି ଏବଂ PW ତାର ଫାର୍ଷ୍ଟ ଷ୍ଟେଟମେଣ୍ଟ ରେ ଅଛି ଆଉ ତା ଛଡା PW 10 ତ କହୁଛି ତେଣୁ से केस रे भी जोटा से प्लेस करूचंदी से केस रे भी इंजुरी तीनटा जो इंजुरी थिला से गुडा को मध्य माइनर इंजुरी थिला केसटा तम सपोर्ट करूची देखियो बोले and what the other decision you are pointing out
Butasin, here the injuries are grievous thila
grievous are chhad me grievous we are not हमें जो तीनटा डिसीजन आइला कि भाई देखिए देखिए first you show that 91 Supreme Court 769 तो भाई पूछा ही था some of the person establish that actually saw the disease and like a apprehension the death of previous injury otherwise these party persons are concerned. We are going to the judges and the evidence that are admitted to the apprehension of the civilian. Some of these alleged to have person, for example, that's differentiated are only simple injury. In the absence of injuries and the accused opponent, it would only focus on Though he had right of privacy, he could not have gone to the extent of having 6 times, then killing one person and in is clearly case of exceeding the right of privacy and counseling submission. Our relied application of so and so and very the same find the defects of the thing. Just to say that so this natural defect and circumstances in having in judging whether the appellant has exceeded the right of privacy, the court has to take into account issues, particularly in the case of filing number so and so. For the appellant to file 6 times in the country as actually it was on it. So and so and so on. The apparent font development the trial for the figure. The learning trial was convicted all the apparent of the figures of trial. It was uncomfortable. You find out that next one is 2001. Sorry points. Yeah, currently 2001. So yeah. Past one right of private they may defend their possession of the product. But as far as the appellant and urgent are they exceeded their right of private defense to the extent of causing injury, which led to the death of person, hence they are liable. Consequence on punishment of figure for part 1 sentence to 10 years. The High Court in the second part of the instruction when the appellant has failed to having death of the then so that this keep expected that so that they don't have a must consider case of the possible second or the consequence. The appellant is having the sentence by and so PW. Danger of the evidence source that the stated that we saw the evidence person in the appellant between cherry and sponsor. Option because the control here and there and so there we are feeling encouraged in this statement so in the attack that responsible for the understand responsible and so no consider the settlement of Indian relationship specifically reference to the second part of this. The next week is but when it's not a favorite, in sense once on rest of friend and father also ran. These people ran in surrenders after then, but really that there is other um, not a problem. After following some distance, there is father and father that's the travel at the third time. That is what should in because of the second incident, we do on it also. Travel. Having come to position the knowledge the line very taking protecting the software. She was in position, but after examining the evidence from the police came conclusion that the son of the however have exceeded the liability punishment period part one Ashok Tiwari. Here we are in reason finding on the found discussed by the High Court. Here the apparent and attack Ashok Tiwari level even after they get falling down on the ground. It occurs by the consequence of head injury, which are resulting in fracture of spine and the injury is sufficient in ordinary course of fracture. The organs of the High Court are right, you can click on the upper and by exiting their right of private at the same time the High Court. So in our opinion, justified in coming from the act of these two persons, namely appellant and appellant, came under exception. So from the same as on a official with that taking consider the nature of article that the act does not come under section 3 but 3 of part 1. Agree with the conclusion. So you have to the act of the appellant and version 3 also should have start relevance on version the conclusion so on so for 10 years we put on and actually for the and then considering factor and reference and find that the appellant is to party paper travel part 1. Okay, next case is it is 2003-12 SCC 756. Let us see. Seven five eight, right? Singara seems like. You want to take it. Okay, but bottom there. So trial could also found Subha Singh, appellant number 1, had 6 injuries on his person, who is then middle index finger, lacerated wound, left leg, swelling, skull, bruise, scapular right side chest, pain, abrasion, right elbow. It could be noted that above injury, that one of the injuries was in skull and caused by long possibility of disease by deep patch canal. Prosecution doctor had the possibility of holding the acceptable number in friend reasons to not the trial to the presence of injury on Subhas which had not been explained by the prosecution supported the people's work. and render within their strong and could have been self-inflicted. It was difficult to believe that so many injuries could have been self-inflicted. It was cheap in our level. The learning staff and in trial court on in Barata. Discussion of the Or so far the case of Subhash Singh is concerned, we agree with the finding of the current trial court that he has exceeded the right of private rights in circumstances. There was no justification for using his phone in such a manner as to cause the death of the deceased without time return for Parliament. So in a year, best area. You have remained in custody for how many years? 8.5.
Kete? 8.5.
तापरे bail ले पड़ी है.
Yes. Registered in 2019. Here, the High Court has converted to 30 Part 1 and 7 years conviction grant. So, Honorable Apex Court has confirmed that.
304 Part 1 ordinarily the sentence they
Not
have
less than
imposed
10
is
years.
10 years. But exceptional case re age base को नहीं कि नहीं जल्दी 7-8 वर्ष ही यही था. They used to do it period already on the
Otherwise,
But what is your age by now?
50.
ଆପଣଙ୍କର 35 ହେଇଥିଲା ଯେତେବେଳେ
2003 ରେ 55.
55. ଆପଣ ଇଏଟା ସେ ଦେଖିଲେ କେବେଠୁ କଷ୍ଟଡି ଗଲା ଏବଂ କେବେ ବାହାରିଲା ଏଇ ଏଲସିଆର ଟା দিয়ে ଦେଖନ୍ତୁ.
Same day.
फाइनल फॉर्म ଟା ଦେଖନ୍ତୁ. ହଁ फाइनल फॉर्म ଟା ନାଁ ହେଲା ଚିତ୍ର.
Custody ଥିଲା 21/8/2003.
ଚିତ୍ରର କାଇଁ ହଁ ଚିତ୍ରଟା ହଉଛି
Same day.
ଆପଣ ଫରୱାର୍ଡ ହେଲେ 23/8/2003 ଜଷ୍ଟ a minute 23/8/2003 forwarded for the first time. Okay, then you are on bail during trial or not? Well, let us see that order sheet. Accused persons produced.
20/10/2011
କଣଟା?
ବିଲ୍
ହଁ
ବିଲ୍
ନାଇଁ ମୁଁ
ଏମିତି
ଟ୍ରାଏଲ
custody
କୋର୍ଟରେ
ଅଛି.
ବେଲ୍ ଥିଲେ
Trial
କି ନାହିଁ ସେ
ଟ୍ରାଏଲ
ଏଠି ତ ବେଲ୍ ହେଲା. Accused okay, other accused persons are produced. No. ଗୋଟେ ସେ ପ୍ରବାସୀଟାକୁ ବେଲ୍ ହେଇଥିଲା. ଚିତ୍ର ନାୟକ ସୋ produced in custody.
Last page 22 ରେ ଅଛି judgment.
କଣଟା?
Produce in court under
ହଁ
custody.
ନାଇଁ ବେଲ୍ ହେଇନାହାନ୍ତି. ତମ ଏଠୁ କେବେ ଗଲା କହୁଛନ୍ତି? ଏଇ
2010 to
20/10/2011
20/10/2011 ତାମାନେ 8 ବର୍ଷ ପାଖାପାଖି 3 ମାସ ହେଇଥିବ ଆଉ. 8 ବର୍ଷ 3 ମାସ. 2011 ମାନେ ଆ ଭିତରେ 12 ବର୍ଷ ପଳେଇଲାଣି. And you are 55 years now.
Yes.
କଣ କରିବା? Take down. JCRL number.
Just
90.
1 minute.
Yes.
Yes.
Why this appellant came with the Ghodisha in front of the house of this deceased? That is
No,
the
no.
intention.
Even if he was armed with a Ghodisha,
Yes.
he has not started the assault till he was assaulted. That you should not
When
forget.
my contention is, when a father saw his son was beating, he retaliated.
He came and started assaulting the
Assaulting
the
two
appellant.
Yes.
So then he retaliated. Otherwise, he was holding. Just think over it. He was this holding a Ghodisha. It rather goes against you. A person who was in possession of a weapon, which is a dangerous weapon.
Yes.
He could have assaulted, but he has remained silent. He has not at first started the assault. The moment the deceased started assaulting, then and your witness have suppressed that part. You see, they are leaving.
Yes.
Taro, so how can this is the state
Apart
of
from
affairs.
that, this PW
We are
Pramod-
holding that he is not that his act is not within that right of private event. He has exceeded.
Yes.
But law is that once he has exceeded, you cannot convict him under 302 of the IPC.
That is true. But this Pramod informant PW9, he has sustained some injuries.
Proved
Not
by
proved. Not proved.
PW12.
No, not proved.
Yes, proved.
Okay,
PW12.
let us see that.
PW12.
What is
Yes.
the nature of injuries?
Dr. P.K. Mishra.
Yes.
For tenderness with no visible abrasion
Abrasion.
over right shoulder.
One
Right
injury on the
side.
blood clot of the right nose.
Old
Injury and
blood clot inside right.
so that's all. That's it.
That
May
is
be
it.
that in the during the first part this thing has happened.
Yes. Then the father came and
No. ଆପଣଙ୍କ first part
first ରେ ବାଡା ବାଡି କିଛି ହେଇନି। ଖାଲି
first part ରେ ହିଁ ବାଡିଆ ବାଡି ହେଇଛି। ଆପଣ ଓଲଟାଟା କହୁଛନ୍ତି। ଆପଣଙ୍କର ଦେଖନ୍ତୁ ଆଉ ଥରେ ଏଭିଡେନ୍ସ ଦେଖନ୍ତୁ। PW15 କୁ ଦେଖନ୍ତୁ। ଫାଷ୍ଟ ପାର୍ଟ ରେ ହିଁ ଯାହା ହେଇଛି ଫାଷ୍ଟ ପାର୍ଟ ରେ ହେଇଛି। Come to PW 15.
Yes. On the date of occurrence 7th, I was cleaning my cycle house front veranda. At that time, the complainant and one Basanta shouted quarrel in front of the house of Nakula Naik of my village. Hence, Nakula Naik father Basanta came there and foretold Pramoda Naik. At that time, accused Chitra Prabhasi and so and so assaulted Pramoda. On our process, they shouted with us and this was.
ସେଇ ଯୋଉ ଫାଷ୍ଟ ପାର୍ଟ ରେ ହେଇଛି ତାପରେ ଆସିଲା ଯେତେବେଳେ ସେ
half an hour
ଦେୟାର ଆଫ୍ଟର ଆସିଲା ପରେ ସେଠି ଜଷ୍ଟ କଳି ହଉଥିଲା କଳି ହଉଥିଲା altercation and he was holding a dangerous weapon. In spite of that, he has not used it. He used it only when he was assaulted, and that too on the vital part of the body. So that is the situation. All right, take down that JCRL number 97 of 2008. The appellant Chitra alias Chitrasen Nayak, along with co-accused persons Bhaskar Naik, Prabhasi Naik, and Kailas Naik faced trial in the court of Lenant Second Additional Session Judge Barhampur in Sessions Case number 26 of 2006 bracket SC number so and so for offences punishable under section 341/323/302 by 34 of the Indian Penal Code on the accusation that on 22/8/2003 at 7 a.m. at Horizon Sai of village Potiguda, they, in furtherance of their common intention, wrongfully restrained Pramod Naik bracket PW9 and his father bracket Anand Naik bracket hereafter the deceased and they voluntarily caused hurt to PW9 and the deceased, and committed murder of the deceased. The London Trial Court, by judgment and order dated 2010-2008, though acquitted the co-accused persons Bhaskar Naik, Prabhashi Naik, and Kailash Naik of all the charges, so also the appellant of the charge under section 341 by 34 of the Indian Penal Code, but found the appellant guilty under section 302 by 323 of the Indian Penal Code, and sentenced him to undergo rigorous imprisonment for life and to pay a fine of rupees 3,000 in default to undergo rigorous imprisonment for a further period of 6 months for the offense under section 302 of the Indian Penal Code, and to undergo rigorous imprisonment for 1 year for the offense under section 323 of the Indian Penal Code, with a further direction that both the sentences are to run concurrently. PW9 lodged the first information report before the officer in charge, Pattapur Police Station, on 22/8/2003, alleging, stating therein that a committee was formed in village Patiguda for preventing the illegal sale of liquor and also gambling activities. And he was one of the member of the said committee. On 21/8/2003, in the evening hours, the appellant Chitro alias Chitro Sen Naik was selling liquor and getting such information, PW9 went to the place of sale and registered the appellant regarding his activities, for which the appellant, his uncle, who accused Prabhasi Naik, and the brother-in-law of the appellant, namely Bashan, came forward to assault PW9, for which he left the place. So it is further stated in the FIR that over this issue, on 22/8/2003, in the morning hour at 7 o'clock,
the appellant started quarrel with PW9 and gave fist blows on his face, and while the quarrel was going on, the three co-accused persons, namely Bhaskar Naik, Prabhashi Naik, and Kailas Naik, came to the spot by bringing lathi and ghodisha from their houses, and the deceased arrived at the scene of occurrence, and the appellant quarreled with the deceased. The other co-accused persons also participated in the quarrel, and all the accused persons attacked the deceased, and the appellant was holding a ghodisha, assaulted on the head of the deceased, so also pierced it and the chest of the deceased, as a result of which the deceased sustained bleeding injuries and fell down under a coconut tree. The who is that IO? Investigating officer की है?
PW
16.
Yes.
अच्छा. The PW9. One Utsav Naik has been examined, that the scribe of the affair.
Yes.
As PW? Acha, 11.
11.
One Utsav Naik, bracket PW 11, scribe the FIR as per the instruction given by PW 9, and thereafter the same was read over and explained to PW 9, who put his LTI on the written report, which was lodged at Patapur police station. PW 16, Sisir Kumar Mishra, the officer in charge of Patapur police station, on receipt of the written report from PW 9, registered Patapur PS case number 100 dated 22/8/2003 under section 341, 323, 302, 506 by 34 of the Indian Penal Code against the appellant and three co-accused persons, namely Bhaskar Naik, Prabhashi Naik, and Kailas Naik. PW 16 proceeded to the village, and during course of investigation, he examined the informant and bracketed PW 9 and other witnesses, visited the Harijan site of village Patiguda had prepared the spot map by Exhibit 28, conducted inquest over the dead body of the deceased and prepared the inquest report Exhibit 10, seized the bloodstain, bloodstain damaged palm mat from the spot, bloodstain towel and bloodstain earth and sample earth from the spot in presence of the witnesses as per seizure list exhibit 3 no exhibit 3 by 1 and yellow color gents cloth he also seized the wearing apparels of the deceased which were stained with the blood on being produced by the wife of the deceased as per seizure list exhibit 4. He arrested the appellant and the co-accused persons who were detained by Gramrakhi and during the appellant while in police custody confessed his guilt and disclosed to have concealed the weapon of offense behind the tatty door of the front room of his house, and accordingly the statement of the appellant was recorded and he led PW16 and other witnesses to the place of concealment and gave recovery of the weapon of offense, that is Gidisha bracketary MO2, which was seized as per seizure list exhibit 5 by 1 and the dead body was sent for post-mortem examination to MKCG Medical College Hospital, and the weapon of offense was also sent to the doctor and PW2 conducted post-mortem examination and prepared the post-mortem report, and he also examined the weapon of offense and gave his opinion that the injuries sustained by the deceased were possible by such weapon. The appellant was also sent for medical examination and his sample blood and nail clippings were collected, which were seized. The lungi of the appellant was also seized. The wearing apparels of the other co-accused persons were also seized. The informant bracketary PW9 was sent for his medical examination to medical officer Podamari Hospital and PW16 received the PM report and the injury report in respect of PW9. He also received the injury report of the appellant Chittaranayak. He made a prayer to send the to the court to send the exhibits to RFSL Barampur. The statements of some witnesses were recorded under section 164 CRPC by Lanen JMFC Digpandi on the prayer made by PW16, and on completion of investigation, charge sheet was submitted under section 341, 323, 302 by 34 of the Indian Penal Code against the appellant and 3 co-accused persons. The case was committed to the Court of Sessions, where the London Trial Court framed the charges as aforesaid. Since the accused persons pleaded not guilty and claimed to be trial, the sessions trial procedure was resorted to prove their guilt, establish their guilt. In order to prove its case, the prosecution examined so-and-so witnesses. Exhibits are this, so-and-so are the material objects. The defense plea of the appellant is that the deceased first assaulted him with a lathi on his head, and at that point of time, the informant PW9 came and snatched away Ghadisha from his hand, which accidentally pierced in the chest of the deceased, as a result of which he died. The London Trial Court, after assessing the oral as well as the documentary evidence on record, came to hold that on the basis of the evidence of the Dr. PW2 and the postmortem report Exhibit 2, it has been established that the death of the deceased was due to stab injury caused to him by means of MO2. The London Trial Court came to hold that the discrepancies appearing in the statement of the eyewitnesses are minor in nature, and since the evidence of the prosecution is getting corroboration from the 164 CRPC statement recorded by the court, it can be said that the prosecution has successfully established that the appellant Chitra caused the death of the deceased by giving fatal stab blow at the chest of the deceased by means of Gidisa, MO2.
It was further held that the appellant gave 2 blows to the deceased, and the subsequent stab blow was with intention to cause death of the deceased, and therefore he has committed the offense of murder punishable under section 302 of the Indian Penal Code. The London Trial Court then discussed the evidence on record to find out whether there was any a prior meeting of minds between the accused persons, and it was a predetermined plan for murdering the deceased. And after discussing the evidence on record, came to hold that the co-accused persons, Bhaskar, Prabhasi, and Kailas, cannot be held liable for killing of the deceased with the aid of section 34 of the Indian Penal Code, and accordingly acquitted them of the charges under section 302 by 34 of the Indian Penal Code. Similarly, the London Trial Court has been pleased to held that there is nothing that the accused person surrounded the informant bracket PW9 and obstructed him in any manner from proceeding in any direction in which PW9 had a right to proceed, and therefore no offense under section 341 IPC is made out. So far as the offense charged under section 323 of the Indian Penal Code, it was held that in view of the evidence of the doctor bracket PW 12 and the PW 9, it can be said that the appellant Chitra is guilty under section 323 of the Indian Penal Code for voluntarily causing hurt to the deceased. সেটা ইয়েটা কর দিও PW9 में সেটা को deceased कर दियो है ना PW से ये जगह रे 12 आउ PW9 करी accordingly while acquitting the co-accused persons of all the charges, so also the appellant under section 341 by 34 of the Indian Penal Code found the appellant guilty under section 302 by 323 of the Indian Penal Code. Mr. Pulakesh Mahanti, London Counsel, appearing for the appellant, contended that from the materials available on record and the specific plea that has been taken by the appellant, it appears that it was the deceased who first started the assault, and on the appellant, and with a lathi, and the and PW1, the doctor who examined the appellant on police requisition on the date of occurrence itself also found injuries on the scalp as well as on the right supraclavicular region of the appellant. The London Counsel submits
that the two eyewitnesses to the occurrence, that is PW9 and PW15, have not explained as to how the appellant sustained such injuries, and they have suppressed the same, and therefore they cannot be said to be truthful witnesses. Moreover, when PW9 has stated about the participation of three co-accused persons, namely Bhaskar Naik, Prabhashi Naik, and Kailash Naik, in the assault of the deceased, the evidence of the eyewitness PW15 is completely silent in that respect. The doctor who conducted post-mortem examination also did not find any corresponding injury to the assault of the three co-accused persons, and therefore the evidence of the two eyewitnesses are contradictory to each other. The Learned Council further submits that in view of the assault part on the appellant, which has been deposed to by PW10, so also PW15, and the medical examination report of the appellant, it can be said that the appellant has acted in exercise of his right of private defense, and therefore, in a case of this nature, benefit of doubt should be extended in favor of the appellant. Learned Counsel for the appellant placed reliance in the case of Lakshmi Singh versus State of Bihar, reported in AR 1976 bracket 4 bracket bahare, Supreme Court cases 394. Moti Singh versus State of Maharashtra, reported in 2002, volume 9, Supreme Court cases 494. The Mr. Tripathi led an additional standing counsel, on the other hand, supported the impugned judgment and submitted that the quarrel and the assault on PW9 started from the side of the accused persons, and PW9 has sustained some injuries which would be evident from the evidence of the doctor, that is PW12. And again, after the half an hour of the first quarrel, when another quarrel took place, the deceased came to the spot, and at that point of time, he was assaulted by the appellant, as would appear from the evidence of PW9 and PW15. And both the witnesses have stated that the appellant used Gidisa for dealing the first blow on the head of the deceased, and then pierced the Gidisa on the in the chest of the deceased. and and that too after the deceased fell down on the ground. He submitted that the doctor has noticed two corresponding injury on the scalp as well as on the right side chest, and when the weapon of offense was seized at the instance of the appellant, the same was also sent to PW2 for its examination, and the doctor, after examining the weapon of offense, has given his opinion as per his report Exhibit 2 that the injuries noticed on the deceased can be caused by the weapon uh, produced before him, and therefore the ocular evidence of two eyewitnesses, that is PW9 and PW15, getting corroboration from the medical evidence adduced by PW2. The London Council further argued that the injuries sustained by the appellant are simple in nature as deposed to by PW1, and therefore it cannot be said to the appellant that he would receive any grievous injury, and therefore the act of the appellant in assaulting the deceased with gidisha, that too on vital part of the body like head and chest, would indicate that his intention was to commit murder, and it would not come within the right of private defense. The London Council for the State further highlighted that from the statement of PW15, it would appear that after the deceased was assaulted, he uh, assaulted the appellant by lathi, and therefore it cannot be said that on the deceased first assaulted the appellant, and therefore when no private right of private defense is available to the appellant, and the nature of injuries sustained by the deceased have been opined to be on the cause of death was opined to be shock and hemorrhage resulting from the injury to the vital organ like heart, and the London trial court has rightly found the appellant guilty under section 302 of the Indian Penal Code. Adverting to the contention raised by the London Council for the respective parties, let us first examine the evidence available on record to show how far the prosecution has succeeded in establishing that the deceased met with a homicidal death. PW2 on 22/8/2003 conducted post-mortem examination over the dead body of the deceased, and he noticed the following injuries: quote Kardavati 1 and 2, and on dissection he found like this, and he has opined that the injuries were antemortem in nature, and injury number 1 would have been caused by moderately heavy and hard blunt force, and injury number 2 would have been caused by moderately heavy multi-edged pointed weapon. The cause of death was due to
shock and hemorrhage resulting from injury to the vital organ, that is heart. And the doctor also examined the weapon of offense which was sent by the IU, and opined that the weapon was containing bloodstain, and the injuries uh, noticed on the person of the deceased would be caused by such weapon. And he has submitted his report Exhibit 2. The nothing has been brought out in the cross-examination of PW2. Stop. The learned counsel for the appellant has also not seriously challenged the that the death of the deceased was homicidal in nature. Therefore, on the basis of the inquest report, the evidence of the doctor bracket PW2 and the postmortem report kete mark hechi exhibit exhibit 2, we are of the view that the Lenin trial court has rightly come to the conclusion that the deceased met with a homicidal death, and the stop. Now, coming to the evidence of the two eyewitnesses, that is PW9 and PW15, we find that PW9 has stated that on the date of occurrence, the appellant, along with others, quarreled with him at Tipu Bandha, and then he returned home, and on the next morning at about 6 a.m., the accused persons came near his house and quarreled with him, and all on a sudden, the co-accused Prabhasi Roy gave him 2 to 3 blows, fist blows on his nose, and then the other accused persons, including the appellant, surrounded him, and at that time, the deceased was coming towards PW9, and seeing the deceased, the accused persons left PW9 and rushed towards the deceased. And at that time, the appellant, who was armed with Gidisha, and the other accused persons who were armed with Thenga, assaulted the deceased, and appellant assaulted on the head of the deceased, as a result of which the deceased fell down on the ground, and thereafter the three co-accused persons assaulted him by means of lathi. And while the deceased was lying on the ground, the appellant stabbed on the abdomen of the deceased with the hadisa, which caused bleeding injuries. The PW2 also stated that on account of assault on him, he also sustained injury on his nose and right shoulder. The the other eyewitness, that is PW15, though stated that at the time of occurrence, when the deceased came, the appellant Chitra dealt a blow on the head of the deceased by a Gidisa, and then pierced the Gidisa on his belly
but for which the deceased died at the spot, but his evidence is completely silent regarding participation of the co-accused persons in the assault of the deceased. There are also no corresponding injuries on the deceased to substantiate any assault by the co-accused persons. And that was the reason why the London trial court disbelieved the participation of the co-accused persons in the assault of the deceased and acquitted them of all the charges. The evidence of PW 5 indicates that he has stated before police, which he has admitted in the cross examination, that it was the deceased who arrived at the spot and assaulted the appellant by lathi, and PW 15 further stated that he has stated the same thing before the magistrate. Therefore, the PW 15 has tried to suppress that the deceased was the aggressor and he came to the spot holding a lathi and started assault on the appellant. PW 10 has stated that he found that the deceased assaulted the appellant by means of a stick on his head, and thereafter the appellant assaulted the deceased by means of gidisa, and on his head, for which he he stabbed the gidisa on the chest of the deceased, for which he fell down. The evidence of this witness PW 10, coupled with the previous statement of PW 15 before police as well as the magistrate, and the evidence of PW 1, who has noticed one lacerated wound on the scalp of the appellant, so also another contusion on the right supraclavicular region, though has been opined to be simple in nature, but the doctor has stated that it can be caused by hardened blunt weapon. Therefore, the plea which has been taken by the appellant is that it was the deceased who first assaulted him on the head by a lathi, is getting corroboration from the evidence of two prosecution witnesses, that is PW 10 and PW 15, so also from the medical evidence adduced by PW 1. The question that crops up for consideration is whether, after receiving such injury, when the appellant assaulted the deceased and cause the injuries as noticed by the doctor bracket PW2, whether it can be said that he was within the right of private defense or he exceeded the right of private defense. In the case of Lakshmi Singh and others, the state of versus state of Bihar reported Agutto for it has been held that in a murder case, the non-explanation of the injury sustained by the accused at about the time of occurrence or in course of altercation is a very important circumstance from which the court can draw the inference that the prosecution has suppressed the genesis and the origin of the occurrence and has not thus not presented the true version, and that the witnesses who have denied the presence of the injuries on the person of the accused are lying on a most material point, and therefore their evidence is unreliable, and that in case there is a defense version which explains the injuries on the person of the accused, it is rendered probable so as to throw doubt on the prosecution case. It has been further held that the omission on the part of the prosecution to explain the injuries on the person of the accused assumes much greater importance where the evidence consists of interested or inimical witnesses or where the defense gives a version which competes in all probability with that of the prosecution case. In the case in hand, the no doubt the defense plea taken by the appellant that he was assaulted first by the deceased with a lathi on the head is getting corroboration from the two prosecution witnesses as already stated, including the medical evidence adduced by PW1. But the further plea taken by the appellant that when receiving the blow from the deceased on his head, he fell down, at that point of time, PW9 came, snatched the ghidisa from his hand, and it pierced in the chest of the deceased, seems to be not acceptable in as much as the deceased has sustained two injuries, one on the head and the other on the right chest. The injury sustained by the PW1, the injury sustained by the appellant as noticed by PW1 is no doubt simple in nature, but it cannot be said to be minor or superficial one. Moreover, it is on the vital part of the body. And therefore, after receiving the blows, there would have been a reasonable apprehension in the mind of the appellant. But whether the apprehension would extend, would give the appellant the right to cause the injuries as noticed on the deceased proved by PW2 or not is the most relevant consideration. In the case of Moti Singh, cited by the London Council for the appellant, it is held as follows. Quote कर दीजिए से जो paragraph उड़ा को quote कर दो, है ना? The
यो जो 3 केसेस हमें ये करछु से 3 केस रो रेलेवेंट पैराग्राफ मध्ये मु साई ये करछि तब कोट कर दे है ना. After going through the ratio laid down by the Honorable Apex Court in the aforesaid decisions and considering the evidence of the 2 eyewitnesses, the evidence of the doctor, PW1 and PW2, we are of the view that though the appellant has received injuries on his head and also on the right supraclavicular region, which was caused on him by the deceased with a lathi at the time of occurrence, and it was also caused fast, but the manner in which he retaliated and caused the injury on the right front parietal area, so also the stab wound on the right chest, which caused very serious impact on the deceased and proved fatal. We are of the view that by causing such injuries on the deceased, the appellant has exceeded his right of private defense, and therefore, in view of the ratio laid down by the Honorable Supreme Court and keeping in view the exception 1 to section 300 of the Indian Penal Code, we are of the view that it is the act of the appellant would not come within section 302 of the Indian Penal Code, but it would come within section 304 part 1 of the Indian Penal Code. It is we find that the appellant was taken into judicial custody on 23/8/2003, and he was never released on bail during trial. And after he preferred this jail criminal appeal, he was granted bail by this court on 2011. Sorry, 2011
कोड़िए दस कोड़िए कोड़िए दस
10 ना 10 अच्छा ठीक है. So 2010-2011, and thus he has undergone the substantive sentence of 8 years and 2 months. But the occurrence took place in the year 2003, and in the meantime, more than 20 years have passed, and the appellant is on bail for last more than 12 years, and therefore it would not be proper. Therefore, we think it proper while convicting the appellant under section 304 part 1 of the Indian Penal Code. We think it proper to reduce the sentence period already undergone. Accordingly, the jail criminal appeal is partly allowed. एवढा सब चिन्ह मरायचे देखिए लिखिले. So that's all for today.
Yes, ma'am.
to be listed on 11th December. Till that it is not. All the co-accused persons have been listed.
Pardon to mention on item 83, the Lordship, last occasion, me and Mr. Bigyan Sharma adjourned the matter. That connected matter is adjourned to tomorrow. Both the matter be taken together, my lord. Item 83, along with 11234 of 2023 BLAPL.
देखियो कौन है?
83 का
item
11,234 से
the sole player of the presentation for interim bail on the grounds of the accused person suffering
Tally की
cancer. Can you take it up today?
Item 97, my lord, not press, my lord. 97, not press, my lord. Not press, my lord. 97.
'97, that is ABLAPL number 13431 of 23. Not press.
Pardon, madam. Item 39, madam. Main accused has been released on bail, madam. More than 5 months in.
Why are you mentioning? Yes, next.
My lord, pardon to mention, my lord. By your lordship's order, the appellant petitioner was directed to furnish property security in place of cash security.
Which item?
My lord, out of list mentioned,
Give
my
the
lord.
memo.
My lord, the warrant has been issued. My
Give
only
the memo.
predicament, my
Give the
lord,
memo.
says suffering from cancer, my lord. On that ground, lordship has granted.
All right.
My lord.
Yes.
My lord, BLPL number 9352 by 23. 18/10 ରେ ଉଠିଥିଲା ଆଉ ଏପର୍ଯ୍ୟନ୍ତ ଆସୁନି।
Give the memo. Give the memo.
Madam, item 47, my lord. So wrongly the listed in list, my lord. The earlier disposal by honorable
We'll see
justice.
that. Maybe that prior to that I have disposed of another bail application of another accused. So wait, we'll see that. Yes.
And the extension of time over the
We'll see
anticipatory
that when
bail.
the matter reaches to make
My
mention.
lord,
Like
mention, my lord.
may give the memo. Yes.
I beg your pardon, my lord.
Yes.
CRLA 260 of 2020, my lord. It was lastly posted on 14/11/23.
All right, noted down. Yes.
Obliged, my lord.
In view of the foregoing discussions, I am of the humble view that when material witnesses on behalf of the prosecution have been withheld and the defense plea seems to be more acceptable, which also gets corroboration from the prosecution witnesses like PW3 and PW4, and there is no clinching evidence that the appellant Narendra Sethi, while carrying the rice of 5 BPL card holders, has committed the act of misappropriation in connivance with the appellant Manoj Kumar Mahanti, and when material questions have not been put in the accused statement, it cannot be said that the prosecution has successfully established the charge under Section 7 of the Essential Commodities Act against the appellant. In the result, the criminal appeal are allowed. The impugned judgment and order of conviction of the appellants under Section 7 of the EC Act is hereby set aside. Yes.
Supplementary list, item number 1.
None appears for the petitioner. The bail application has been disposed of as per order dated 30/3/2021. And this interim application has been filed for modification of the order dated 30/3/2021, wherein it is stated that instead of Pike Mall PS case number 71 of 2019, Pike Mall PS case number 171 of 2019 should be mentioned in the order sheet. Here is the FIR. The learned counsel for the state has no objection. Accordingly, in the order dated 30/3/2021, where Pike Mall PS case number 171 of 2019 has been mentioned, the same shall be read as Pike Mall PS case number 171 of 2019. The rest part of the order dated 30/3/2021 remains unaltered. IA is disposed of.
Item 2.
May I please, Your Lordship? But I filed an application which Your Lordship will take up for consideration. That on the date of the matter was taken up, I was on my legs in another court for reason which I could not appear on that particular time, and I made a mention immediately before Your Lordships to take up this matter, which Your Lordship said that you file a IA application for recall. Accordingly, with taking your Lordship's liberty, I filed this IA application for recalling of this order which Your Lordship had passed.
What order was passed?
Your Lordship had passed that disposed of by giving liberty.
You move another application there.
To move another, but I wanted to address on merits because it was a
move again and come.
Your Lordship had thereafter.
IA numbers 1.
My Lord, Your Lordship will see one thing.
Dismissed. Yes, next.
Your Lordship, both the applications have been
move,
filed.
Move again.
167(2) my remedy is before Your Lordship.
Yes, next. Yes, same order in item number 3.
Your Lordship called for a report.
Yes, next.
Item 4.
Yes, item 4. You have received the case diary, Mr.
Yes, Miller. Case diary.
Let's pass over next.
Item 5.
Yes, item 5.
Sir, I am in custody.
see the order dated 22/9/23, my lord. On my affidavit, your lordship is directed to take instruction regarding the genuineness of this petitioner's address, my lord. Because earlier, without going to the spot, the police has given one report that no such person was staying there.
Yes.
For that, I have filed another affidavit, my lord, because my forefathers are staying there.
What is your instruction on the additional affidavit which you have?
Yes, my lord, additional affidavit has been sent to the police, but no instruction received so far.
But it was dated 22/9/2023, almost
Yes.
3 months have passed.
My lord.
So, all right, since it is the laches, you file your that local sureties names, address, and
Today I am supplying, my lord. My clerk is there, he will supply, my lord.
the Learned Counsel for the state submitted that as per the order dated 22/9/2023, even though instruction has been sought for to verify whether the address furnished in the cause title of the bail application on sound OG is correct or not, but no instruction has been received. 3 months have already passed, is going to be passed. Let the Learned Counsel for the petitioner supply the names, address, and documents of 2 local sureties who are interested to take the petitioner on bail, on receipt of which the Learned Counsel for the state shall obtain instruction to the inspector in charge of Mohana police station regarding the genuineness of the bailers and the authenticity of the documents supplied, put up this matter after ensuing Xmas holidays.
Already documents supplied, my lord, of the bailers.
All right, next.
Item 10.
Obtain CDN. Understand?
Have you?
No, my lord, it did not.
2 months have passed.
Yes.
Similar co-accused person granted bail, your lordship interim bail for 3 months.
No, your bail application. This is your first bail application or earlier?
Second bail.
Second bail application.
Yes.
So what is the number of that earlier bail application? And what is the order passed in that application?
946 of 21, my lord. The BLPL number.
You withdraw that application?
Yes, my lord. Coding advance.
Transfer on the basis of the confirmation. Yes, Mr. Tripathi.
Yes,
why your IIC is not sending the case diary? 2 months have passed. That is, this would be the 7th order. It is Chaudhar police station. Ask him to get the case diary and reach here in his motorcycle or appear immediately through virtual mode. Chaudhar police station ru ଆପଣଙ୍କର କେସ୍ ଡାଏରୀ ଆସିବାକୁ 2022 ମସିହାର ବେଲ୍ ଆପ୍ଲିକେସନରେ ତ you see, live streaming, everybody is hearing about this.
Yes, Imran.
So the competency is known to everybody now. Yes, next. I'm passing it over. Yes.
Item 12.
I have supplied a copy to the learned ASC, my lord.
That is not on record, Mr. Roy.
Not on record, my lord.
What is that IA number?
166023.
For what purpose it has been filed for interim bail? On what
Lord,
ground?
due to spondylitis, acute spondylitis, my lord, the doctors have advised for a surgery, my lords, and he was shifted to hospital even.
From the jail, he is now hospitalized.
Yes, yes.
Okay, that you have mentioned in your that.
My lord, paragraph 2, my lord.
You have received the copy.
Yes, my lord.
All right, get that IA, huh? Lekhundu, IA, Learned Counsel for the petitioner submits that he has filed an interim application for interim bail, which has been numbered as IN number 1660 of 2023. On the ground of element of the petitioner, who is stated to have been hospitalized, Learned Counsel for the state submits that he has received a copy of the interim application and seeks some time to obtain instruction. Put up this matter on such and such date with IN number 1660 of 2023. The instruction on the IA be obtained in the meantime. Hello? Yes.
Item 14.
Yes, Mr.
Lordship.
Akash Bhuiya. Yes.
Sir, in this matter, prisoner petition name of Mr. Aniruddha Das.
Prisoner's petition
Came in the name of Mr. Aniruddha Das.
Aniruddha Das. Yes. What do you want? Aniruddha Das has filed the Bhinama. File. Peruse the prisoner's petition in which the request has been made for engagement of Mr. Aniruddha Das as his counsel. Mr. Das has filed the Bhinama, which is taken on record. Yes, do you want to move the bail application today or?
Yes.
Okay.
You
have received the case diary?
Yes, ma'am.
So is it your first bail application or earlier rejected?
Earlier rejected.
What is the number?
What is, let's say, BLAPL number 7432 of 2020.
Okay. Here, how many petitioners are there? One, Vishwamitra Sahu. So Vishwamitra Sahu was petitioner number 3 in that case.
That's it.
Right.
In the meantime, all the co-accused persons released on bail by your lordship.
Yes, just a minute.
Your lordship directed to my learned senior to take instructions in this matter.
Learned counsel for the state son produce the case diary, play the statement of injured eyewitness Dhumma alias Mohada Majhi, who stated about the assault made by the petitioner by Medha and Brickbat, and the postmortem report also indicated there were injuries over the occipital region, fracture of the skull bone, injury and membrane, so on. So yes, sir. So who has been released on bail?
That's Chaturveda Sahu and Sanjay Sahu.
Mr.
Yes, Miller.
Tripathi, have you received those bail order copies?
No, Miller.
That's it. What copy?
No, pass on to them. And please verify that eyewitness Dhumma alias Mahada Majhi,
Yes.
whether the petitioner stands on the similar footing or not.
That's it.
And this petitioner having 2 criminal activities.
No. First, tell me about this parity. This Dhumma alias Mahada Majhi, या statement को मैं consider करथिली. He has stated about the assault on the deceased by the accused persons by Medha and Brickbat, and he said that these कौन था ना से कौन पहुंचेंदी समाने bail ले जाइचेंदी बेली. Same footing की कौन देखो?
It's omnibus allegation.
ଆପଣ ନାର କିଛି ସ୍ପେସିଫିକ କହିନି
No,
ଏଇ ପାର୍ଟ କୁ ମାରଲେ ଏମିତି କଲେ ଇଆ
No, lordship.
EW5 Miller.
EW80 eyewitness.
EW5 like
Sorry, 5.
डिपोजिशन कॉपी कहीं who is the eyewitness?
EW5
से जो लोकड़ा जा ना
yes.
हाँ PW5 अच्छा देखिए
Copy.
PW5 yes right. The occurrence took place once so The omnibus nature of allegation ଅଛି କାନରେ specific ନାହିଁ.
Specific ନାହିଁ, I mean, so-
Except that he has got two criminal entities.
Yes.
All right. Had the land and counsel for the petitioner, land counsel for the state. The land and counsel for the petitioner submitted that the petitioner is in judicial custody since 6/7/2020, and he has been charge sheeted under section 147, 148, 341, 294, 302, 307, 149 of the Indian Penal Code. When the petitioner earlier approached this court for bail with co-accused persons in BLAPL number 7432 of 2020, the bail application of the petitioner was rejected as per order dated 22/3/2021. However, in the meantime, trial has commenced. Some witnesses have been examined, including the injured eyewitness, namely Dhumma alias Mahada Maji as PW5. He further stated that similarly situated co-accused persons, namely S.K.SAHOO and Sanjay Sahu, have been released on bail by this court in BLAPL number so-and-so, had order dated so-and-so respectively. He files the copy of the order which are taken on record. Land counsel for the, and therefore the bail application may be favorably considered. Seal Marigan Dokosh. The land and counsel for the state, while not disputing that as per the evidence of PW5, the petitioner is similarly situated like the co-accused persons who have been enlarged on bail, but oppose the bail application mainly on the ground that the petitioner has got two criminal antecedents. Considering the submission nature of acquisition nature of evidence adduced during trial, period of detention of the petitioner in judicial custody for more than 3 years and 5 months, and release of the co-accused persons on bail, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail. Shall not try to tamper with the evidence, appear before the learned trial court on each date when the case would be posted for trial. Yes.
Item 15.
May I please, Your Lordship? My Lord, earlier bail application of the present petitioner was rejected by this honorable court. That on observation, my Lord, by order dated 9/1/2023, by BLAPL number 6110 of 2021.
Hurry that rejection order.
My Lord, not rejection, but Your Lordship was liberty was given to renew your prayer after some time, my Lord. And thereafter, my Lord.
Wait, let me see that. Okay, you are in custody since when?
My Lord, I am in custody since, my Lord, 24/8/2020. And my Lord, standing on the similar footing that the present petitioner is the helper, and my Lord, that another co-accused whose interim application was allowed by this honorable court, my Lord, by order dated, my Lord, 1/12/2023 recently, that he stands on the similar footing and he was on the vehicle. Driver has already released on interim bail for a period of 3 months, my Lord. This is the order of the driver, and this present petitioner who is before your lordship is the helper of that vehicle, and the address of the driver and helper are in the same village, and they are.
What are the charges, charge sheet submitted under section?
Charge sheet, my Lord, submitted under
20B to C,
20B.
Yes.
25 and 29 of
And
who is that co-accused driver who has been released on bail?
My Lord, in this order, all the things are elaborately, my Lord, discussed. And this present petitioner's village and the driver's village are in the same place.
Wait.
And status.
So, have you obtained that address verification?
Coming first time to this.
Okay.
My Lord, if your lordship will kind of a glance to this, the order of this.
Shall verify whether the address furnished in the cause title is correct or not. The learned counsel for the The Superintendent of Police Gajpati at Parla Community shall make necessary communication with the Superintendent of Police of IRIA in the state of Uttar Pradesh of this matter after ensuing Xmas holiday. Yes, next.
My lord, driver's address verification was
Yes,
called
next.
for.
Next.
Item 16.
Yes. In this case, my lord, the petitioner is in custody since 2018, my lord. Commission of Offence Order 307, my lord. While he is an interim bail, he was taken to custody in another case, my lord. Kindly have a glance to order dated 19/5/2023.
So, what is the trial position?
My lord, that is only IO was remaining, and probably was no more. For that reason, trial was halted. For that reason, I availed the interim bail. That instruction may be called for.
When you availed the interim bail?
That was extended on 19th May of 2023. While he is on interim bail, he is taken to custody in another case. He must be in remand in this case.
What is the stage now?
The present case.
Yes. In the
trial was halted due to want of IO. Appearance of IO.
Okay, the London Council for the petitioner submitted that even though the petitioner was taken into judicial custody on 9/4/2018 and he was granted interim bail for some time, and the trial has almost reached at a concluding stage so far as from the prosecution side is concerned, but due to non-appearance of the investigating officer to give his evidence, the trial is lingering. In view of such submission, let a status report be called for from the London Assistant Session Judge cum Chief Judicial Magistrate Cuttack in ST case number 237 of 2019. Put up this matter.
Another thing is that he must be remanded to this case, my lord, because of
taken on remand in this case कर दो से जो डेट टा पकेला ना डेट ठीक रहेगा कस्टडी जारी taken on remand कर दो
नहीं
ना रिमांड है ही नहीं सर
तो से इंस्ट्रक्शन था
ही के
ना सरेंडर कर आके था
ठीक है कोट he was released on interim bail mala yes then he was arrested in another case in this case he has not been taken into remand the last occasion mala on 19/8/2023 that interim order was extended so he has now to be taken into custody in this way as a remand on remand mala no if he was not in custody in connection with this case then why he was granted interim bail prior to that granted he was in this case he was interim on custody mala no he during custody he was allowed interim bail then after the one before the surrender he was arrested in another case so taken into custody in that case so he didn't surrender in this case my lord so thereafter he played before my lord and he on 19/8/2023 the interim order was extended but till that he has not been remanded in this case because that case is he is arrested in another case in his custody so he has to surrender in this case again no surrender na apun se to custody remand he has been that intimation has to be given that intimation has to be given either from the public prosecutor or from the side of the accused that I have been taken into custody in so and so case that should be called for report the London Council for the London Council for the state submitted that the petitioner was on bail in this case but taken into custody in connection with another case and thereafter he has not been taken into custody in connection with this case on remand. In view of such state of affairs, the London Trial Court shall, while submitting the status report, mention whether intimation has been given to the court about the case number and the court number in which the petitioner has been taken into judicial custody and whether he has been taken on remand in this case or not. Yes, next.
Item 17.
After Xmas holidays, huh?
Item 17, my lord, offence under section 302 along with other offence, my lord.
Is it your first application or earlier rejected?
First application.
Then 2075 kahar application?
2075 is the co-accused. Kindly, your lordship, that order may be kindly paid.
This is a case of circumstantial evidence.
Yes, my lord.
But what is the allegation against you?
Allegation, my lord, present petitioner along with the others, my lord. That is the one is Ganga Sahu and another Puna Sahu and others are taken to the.
You are in custody since when?
I am in custody, my lord, 28/5/2022.
Charge sheeted under section?
Charge sheeted under section 364, 394, 302, 201 and 34
Just go
IPC.
slowly. 364?
394?
Yes.
302?
Yes.
201? 34 IPC.
What is the name of the deceased?
This is my lord Mithun Swai.
No direct evidence.
No direct, only for the last scene theory.
Last scene of the deceased in your company?
Yes, my lord.
So who has stated that?
One is kindly peruse that order, my lord, your lordship had reflected. One is Sisupal Swai, another is a Pramod Panigrahi.
So how many days after your last scene, the dead body was found?
2 days after. Occurrence,
That man who was granted bail in BLAPL number 2075 of 2018.
Yes, my lord.
So the allegation against him is also similar in nature?
Similar.
Yes,
I mean better put.
Mr. Dal. Same footing. That last scene that jo Sisupal jo kouchandi witness Sisupal Mithun Swai hela a case ro disease se witness ta na hochi acha Videshi Swai boli jane कार statement apon place करतले
Sisupal Swai I will place
informant place करतला Videshi Swai and state council place करतले Sisupal Swai और Pramod Panigrahi से आ भितर गोटे statement देखि सोल्ड पड़ते Sisupal कौन कौची से relevant part
relevant my
the last scene duty ଅଛି
ଗଙ୍ଗା ସାହୁ କୁନା ସାହୁ ବୁଲୁ ସାହୁ ଡିଲ୍ଲୀ ସାହୁ ଏମାନେ ମିଶି ମିଥୁନ ସ୍ୱାଇଁଙ୍କୁ ସେଠାରୁ ଅପହରଣ କରି ଶେରଗଡ଼ ଆଡେ ପଳାଇଥିଲେ। ଆମେ ବହୁତ ଖୋଜାଖୋଜି କରି ପାଇଲୁ ନାହିଁ। ଆଜି ସକାଳୁ ବଡଗଡ ପୁଲିସରେ ଖବର ପାଇ ଆମେ ପୁଲିସ ସହିତ ଯାଇ
ଅଛି ଦିଲ୍ଲୀ ସାହୁ
yes, yes,
ଆଉ ଗୋଟେ କିଏ ଯାଇଥିଲା ବେଲ୍ ରେ କହୁଛନ୍ତି
ଗଙ୍ଗା ସାହୁ
ନା ଅଛି ସେଠି ଯାଇଥିଲା
ହଁ ଗଙ୍ଗା ସାହୁ
ସେ ଯୋଉ ନାଁ ଟା 5-6 ଜଣ ନାଁ ପଚାରିଲେ ହ୍ୟାଣ୍ଡ ଓଭର ଟୁ ହିମ୍
Ganga Sahu, Punna Sahu, and Delhi Sahu.
Or the Learned Counsel for the petitioner and counsel for the state. Considering the submission made by the Learned Counsel for the petitioner that the petitioner is in judicial custody since 28/5/2020, he has been charge sheeted under section 364, 394, 302, 201 by 34 of the Indian Penal Code. And there is no direct evidence in the case. The case is based on circumstantial evidence. And the main circumstance is the last scene of the petitioner and other co-accused persons in the company of the deceased Mithun Swai and co-accused similarly situated has already been released on bail by this court in BLAPL number 2075 of 2018 as per order dated 10/5/2018, which is not disputed by the Land Council for the state. I am inclined to release the petitioner on bail allowed.
Obliged.
Item 18.
Please.
The earlier occasion, Lordship disposed of in bail number 7497 of 2022. Order dated 25/8/2022. 7497 of 2022.
order kahin? Shamir Behera.
Mailers.
302 case.
Yes, sir. 3 months target.
तो कौन है बर्तमान एटा तो जाइथिले आपण 25/8/2022 रो ऑर्डर
Mailers.
So
that was last occasion Lordship call for the status
report.
Mailers.
Okay, status report is has come and it is mentioned that out of 30 charge sheet witnesses, 27 have been examined and that status report is dated September. So it might have been over now by now.
नहीं ହେଇନି ଆଜି ଯାଏ
So
instruction ହେଇଛି
ଆପଣ କଣ ଆସିଲା ଯୋଉ ସାକ୍ଷୀ ଦେଇଲେଣି କପି ଦେଇଛନ୍ତି?
ହଁ କପି
Mr. What evidence has come against this man?
24 Lordship allowed one bail application Lordship Super Kalia Allocation bail number 28101 of 2022 Lordship but order dated 24/6/2022 copy ଦେଇଥିଲେ ଆଗରୁ ଏଟା
କେତେ ନମ୍ବର କେସ୍ କହୁଛନ୍ତି?
2801 of
2801 ଅଛି ଏଟା ହଉ Client counsel to also submit in the trial of comments as per the evidence of eyewitness, namely Mihir Kumar Mahanti. PW10 देखिले.
Mailers.
The nature of overtact alleged against the petition is that he, along with the co-accused so Santosh Behera, assaulted him by fist blows and kicks, uttering obscene language. So far as the deceased is concerned, PW10 has attributed specific overtact against co-accused Samir. Samir to apono?
Mailers.
Who stated to have stabbed the deceased on the lower abdomen. So how do you claim parity? ଆପଣଙ୍କର ଛୁରୀ ମାଡରେ ସେ ତାର ମଲା
case of the so far the this evidence is concerned Lordship to control the deceased and the present petitioner stabbed the deceased. That is the Lordship. They have been granted bail since 2020
ଧରିଛନ୍ତି ତାଙ୍କ କଥା ଅଲଗା ସେ 34
yes Lordship parity କହୁନି କିନ୍ତୁ 22 ମସିହାରେ Lordship granted them Lordship and 20 ରୁ ରହିଲାଣି 29/9/20 ରୁ
ଆଉ କେତେ କେସ୍ ଅଛି ଆପଣ ନାରେ
ଆଉ କିଛି କେସ୍ ନାହିଁ
ମିଷ୍ଟର ଦାସ ଆଉ ये मारला तो स्टाफ इंजुरी टा ये करची ना
that is there Lordship but so far my suggestion Lordship for Lordship para 17 of that suggestion part Lordship may place Lordship
you see somebody no doubt two persons
my defense plea Lordship the Sanjay assault Sanjay ର ତାର ମାଡ ହେଲା ଭିତରେ ବାପ ପତି ଆସିଲା ତାଦରେ ବାଜି ଯାଇଛି that is
to be appreciated by the trial court but 10 says that it is you who stabbed the deceased
yes that is there was say 10 of para 17 re they suggested that by the defense that the Sanjay and
the defense suggestion is no evidence
yes Lordship that is there ଏ ଦି ଜଣଙ୍କ ମାଡ ଗୋଳ ଭିତରେ ବାପା ପଶି ଆସିଲେ ତାଙ୍କ ଦେହରେ ବାଜିଲା this is the defense Lordship
counsel for the petition learned counsel for the state the learned counsel for the petitioner submitted that the petitioner was taken into judicial custody kebe ni
29/9/2020
29/9/2020 and he has been charge sheeted under section 302 of IPC and other offences and the petitioner was granted interim bail for a period of 3 months by this court in BLAPL number 7497 of 2022 as per order dated 25/8/2022 and after availing the interim bail period he surrendered at right time.
No interim bail
এটা সমীর কি
present petitioner সেটা 3 মাস ভিতরে ট্রায়াল ছাড়িবা কই
sorry when he approved this court last time in BLAPL number so and so this court directed the to the learned trial court to conclude the trial within a period of 3 months from the date of receipt production of the copy of the order. The learned counsel for the petitioner further submit that the said order has not been complied with and some of the co-accused persons have already been released on bail.
two person, one Karia and another Smutiranjan Mehra.
Two co-accused persons have been released on bail, and therefore, in view of the period of detention of the petitioner in judicial custody, the bail application may be favorably considered. The Learned Counsel for the state submitted that PW10 is an eyewitness to the occurrence, and he has attributed specific overt act against the present petitioner, and therefore to have stabbed the deceased, then therefore the petitioner cannot claim parity with the co-accused who have been released on bail. Considering the submission made by the Land Council for the respective parties, the nature of evidence adduced during trial, and particularly the evidence of PW10, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention of the petitioner in judicial custody and the fact that earlier order passed by this court in BLAPL number 7497 of 2022 has not been complied with, I am inclined to release the petitioner on bail for a period of 3 months, disposed of. That's all.
Milord, yesterday, while placing Kanimodhi's case, I submitted before your Lordship that the Honorable Supreme Court has laid down that the election petitioner is required not only to plead material facts, but also to positive statement of material facts, but also give positive statement of negative facts. That your Lordship has taken. Yes. Now, today, I invite your Lordship's kind attention to the Form 2B, nomination in Form 2B.
Of the
38.3, Exhibit 38.
Of the respondent.
No, 38.3, সেটা format.
General
format.
38 by 3 times.
38 ভিতরে আছে।
Yes.
ସେଥିରେ just part 1 ପୂର୍ବରୁ ଦେଖନ୍ତୁ ଲେଖା ହେଇଛି strike out part 1 or part 2.
That you are mentioning.
Which is not relevant. Seemti part 2C1, part 3C1, ସେଥିରେ ଲେଖା ହେଇଛି strike out.
Whichever is not applicable.
Whichever is not applicable.
Here.
ପ୍ରଥମଟା ପାଇଲେ strike off, secondଟା ପାଇଲେ strike out say part 3 ର below ଅଛି जो asterisk mark ଅଛି score out
359 हाँ पाइली हाँ ठीक है स्कोर आउट
এই তিনটা আছে ବର୍ତ୍ତମାନ ପ୍ରଶ୍ନ ଉଠୁଛି ଯେ while deleting part 2 strike off ଜାଗାରେ ଆମେ delete କରିଦେଇଛୁ what is the meaning of strike off strike off ର meaning ହଉଛି delete that is
that you have placed Mr. Mishra
ନାଇଁ ମୁଁ ସେଟା ଦଉଛି କୋଉ ଡିକ୍ସନାରୀ ରେ ଅଛି
ଆପଣ ଡିକ୍ସନାରୀ ରେ ଦେଇଛନ୍ତି ଆପଣ ଡିକ୍ସନାରୀ ଟା ପ୍ରଥମ ଡେଟ୍ ରେ ଦେଇଛନ୍ତି ମୁଁ ସେ ଲେଖିଛି ସବୁ
ନାଇଁ ଗୋଟାଏ relevant
just it's all right just you give that if the meaning of that strike out you have given in one dictionary it is Cambridge I think you have given that it is delete Oxford na Cambridge ଗୋଟେ କଣ ଦେଇଥିଲେ
ନାଇଁ ଟିକେ ୱେବଷ୍ଟର ଟା ଲେଖି ଦିଅନ୍ତୁ
हाँ वेबस्टर से अपन दे दियंती अपन जो डिक्शनरी अच्छी ता मीनिंग देयर इज नो प्रॉब्लम ऑलराइट स्ट्राइक आउट माने डिलीट ऑलराइट ठीक है
इरेज एक्सपोज
ठीक है जी ऑलराइट यस नेक्स्ट
देन ऑक्सफोर्ड डिक्शनरी टा देखते
इट्स ऑलराइट सेम थिंग इट्स
देन ऑक्सफोर्ड एडवांस लर्नर
हां जे जहां दबा के लिस्ट रे दे दे यस नेक्स्ट
देन स्ट्राइक ऑफ टा रहिला मु कहली जे डिलीट मींस डिलीट then Merriam रे भी सेया
leave it you come to the next point it's all right
yes I am coming man CI रे जोटा अछि सेटा भी
आउट
ऑक्सफोर्ड रे अछि डिलीट चेंबर्स रे अछि डिलीट
अछि इरेज रेस्पॉन्स
केते थरो कहिबे आपण सेही जिंस को रिपीट करछन
नहीं
लीव दैट पॉइंट
ना मु सेटा टिके एम्फसाइज न कले
that I have noted down if any other meaning are there you give it in the note
minor
please the time is very short for me yes
then score out ro meaning भी सेया
yes next
तेणु then coming to part 3a part 3a रे kindly look at exhibit DP सेटा होची nomination रो ओडिया version as given by the election commission I invite your lordship's attention to that lordship got it DP exhibit DP इंग्लिश रे जोटा अछि स्ट्राइक ऑफ सेटा ओडिया रे निजे कमिशन कहउचंती काटी दियंत
ठीक है
सेटा टिके नोट करो
तीनटा मीनिंग से स्ट्राइक ऑफ रो मीनिंग जगह लिखितंती ताको काटी दियंती स्ट्राइक आउट पाखे लिखितंती काटी दियंती स्कोर आउट रो पाखे लिखितंती काटी दियंती
yes
then part 3a
yes part 3a
नहीं काटी दियंत रो भी अर्थ देइचंती कमे खंडन करिवा
तरुण शब्द कोशर अछि खंडन करिवा कमाइबा फेडाण करिवा खंडन माने काटी दियंतु बा फेडाण करिवा उडै दियंतु
ओके नेक्स्ट पार्ट 3 रे कोन
पार्ट 3 रे
आउ जोटा माइनर अछि
यस पार्ट 3
रे जोटा अछि सेथरे आपण गोटे प्रश्न करथिले जे जदि येठी कोनोसी ये नहीं इंस्ट्रक्शन नहीं टू काट
Yes.
स्ट्राइक अप और स्कोर आउट और स्कोर अप
हाँ.
बा काटी दियंतु एमती नहीं
Yes.
सेठी काहे काटिले
हाँ.
Submission to your lordship made on the other day was, and today also I repeat the same.
Yeah.
The portions of the nomination which are not applicable or are irrelevant to the respondent, if the said person is struck out or deleted, that will not amount to a substantial difference.
Okay.
Then,
just a minute.
Departure or deletion of the second sentence of column 2 to 8 of part 3A of form 2B is coming under the words misnomer, inaccurate description, clerical, technical or printing error in the nomination paper.
That PW3 has stated.
My lord.
Yes.
Dictionary. These are also available under subsection 4 of section 33.
Just a minute. Yes.
Dictionary law lexicon. Misnomer tari. In law lexicon,
Misnomer, Mr. Mishra, it is mentioned that using one name for another.
Yes, ma'am. A wrong name.
So how,
it's the same thing.
How deleting a line would be, manakara akasar na apana nabha lekhile, gagana lekhile. So it's using one name for the another. So
a wrong name.
My lord. এটা সেম হব বট ମିସନୋମର ମାନେ ୟୁଜିଂ ୱାନ୍ ନେମ୍ ଫର ଆନାଦର ହେଲା ଆକାଶର ନାଁଟା ଆପଣ ଲେଖିପାରନ୍ତି ଆପଣ ଗଗନ ଲେଖିପାରନ୍ତି ନଭ ଲେଖିପାରନ୍ତି କିନ୍ତୁ ଆକାଶର ନାଁ ଆପଣ ଲେଖିବେ ପକ୍ଷୀ ସୋ ଇଟ୍ସ
ନାଇଁ ସେଇଠି ଯୋଉଟା ସେଇ ଭଳିଆ ଥିବ ସେଇଟାକୁ ରିଟର୍ଣ୍ଣିଂ ଅଫିସର ଇଗ୍ନୋର କରିପାରିବ ବା କରେକ୍ସନ କରିବାକୁ କହିପାରିବ 33(4) ରେ Cambridge Dictionary रे misnomer ର ଅର୍ଥ ହେଲା a name that does not suit what it refers to. Webster's Merriam-Webster's dictionary କହୁଛି the misnaming of a person in the legal instrument.
It's an incorrect or wrong name.
Incorrect no wrong name. এই ଯୋଉ ଗୁଡାକ ଥିବ ସେଗୁଡା ରିଟର୍ଣ୍ଣିଂ ଅଫିସର Same thing is also said by misnomer means in Collins dictionary an inaccurate or unsuitable name or term for a person or thing.
नहीं ଏଇଟା କେମିତି ତା ଭିତରେ ଆସିବ ସିଏ ମୁଁ ସେଇଥିପାଇଁ କହୁଛି ସିଏ କହିଦେଲା ବୋଲି ତା ଇଏଟା ବେଦର ଗାର ନୁହେଁ କୋର୍ଟ ହାଜ ଏ ଡ୍ୟୁଟି ଟୁ ଆପ୍ରିସିଏଟ
ନାଇଁ ନାଇଁ ଏଇ ଗୋଟାକ ନୁହଁ ମୋ କହିବା କଥା ଏ ପାଞ୍ଚଟା ଯାକ ଭିତରେ ଯଦି ପଡିବ
ହଁ ପାଞ୍ଚଟା ଯାକ ଭିତରେ ଅଲରାଇଟ୍ କିନ୍ତୁ ମିସନୋମର ଟା କେମିତି ସେଟା ହବ ଗୋଟେ ଲାଇନ ଟାକୁ ଆପଣ ଡିଲିଟ କରିଦେବେ
ମାଇଲ
ମିସନୋମର ମାନେ ସମଥିଙ୍ଗ ଡିଫରେଣ୍ଟ ନଟ୍ ଦ୍ୟାଟ୍ ଡିଲିଟ ଏଇଟା କେମିତି ମିସନୋମର ଭିତରେ ପଡିବ
ନାଇଁ ଡିଲିଟିଂ ମୁଁ ପାଞ୍ଚଟା ଯାକ ଦେଖେଇ ଦଉଛି ତାରି ଭିତରେ ଯଦି ପଡିବ ତା ଭିତରେ ତାର ପାୱାର ଅଛି ସିଏ ଇଗ୍ନୋର କରିପାରିବ କିମ୍ବା କରେକ୍ସନ ସେଥିପାଇଁ ମୁଁ ପାଞ୍ଚଟା ଯାକ ପ୍ଲେସ୍ କରିଦଉଛି। Oxford Odia Dictionary କହିଲା misnomer means name or description that is wrongly applied to something. Then inaccurate description. law lexicon रे अच्छी description रे तले लिखा है कि inaccurate description.
देखो
Description means a person, pilot,
got it, yes sir,
is that which tells that he is and where statute requires that the name, place of abode and description of a person be given and only the name and place of abode are given, there is a total commission of description. It is not a mere case of inaccurate description. ये जो फास्ट सेंटेंस टा नो लिखिले किंतु 3 to 8 से गोटी गोटी करी फिलअप करछि
नो लिखिले नहीं आप 3 to 5 फिलअप ହେଇଛି ପୁରା फिलअप ହେଇକି ନି जेतु नो लिखा ହେଇଛି ତେଣୁ yes ହେଇଥିଲେ ସେ सेकंड लाइन नो आस्तांदा that you have already argued, have noted down
ना एगुडा का देई नथिल ना लॉ लेक्सिकन
हां ना एटा देई नथिले that you can give it in that note, you can just smallly just
ठीक है हां अपन रखी देले मने रही हां then kindly come to clerical error. लॉ लेक्सिकन रे अछि एटा
क्लरिकल एरर अछि ना एरर भीतर अछि
नहीं क्लरिकल एरर टोटल क्लरिकल एरर ता गोटाए फ्रेज ता
जस्ट ALM
Wharton defines पहले ना
yes yes
a clerical error as an error in a document which can only be explained by considering it to be a slip or mistake of the party preparing or copying it. Literally, an error is said to be a clerical error where it is made by a clerk or some subordinate agent, but actually it means an error committed in the performance of clerical work, whether by the court, the draftsman of the act, or by the clerk. It is an error which cannot reasonably be attributed to the exercise of judicial consideration or discretion. An ordinary mistake made by a clerk in copying a legal document, the court may itself correct it without motion of the parties. section 152 रे जो अच्छी CPC रे correction of the decree सेटा पार्टी की नजर नोटिस न दे के भी court can correct it. Then technical error. हाँ law lexicon रे आउ गोटे भी अच्छी. A clerical error is one made in transcribing or otherwise, and it must be apparent on the face of the record and therefore capable of being corrected. It is in the nature of an inadvertent omission or mistake. The term clerical error, which is amendable non-pro-tongue, is distinguishable from a judicial error, which can be corrected only on a review or an appeal. Then, my lord, kindly come to technical error.
Yes,
देखो टेक्निकल एरर टा पूरा আছে
टेक्निकल एरर अछि ना
खाली एरर रे देखंतु सेटा टेक्निकल डिफेक्ट बोले की कहछन
एरर
ERROR
PQR अच्छा ERR हाँ एरर असला
आगे
तादेर
a mistaken judgment or incorrect belief as to existence or effect of matters of fact, or a false or mistaken conception or application of the law. Such a mistaken or false conception or application of the law to the facts of a cause as will furnish ground for a review of the proceedings upon a writ of error. A mistake of law or false or irregular application of it, such as vitiates the proceeding and warrants the reversal of the judgment. Error is also used as an elliptical expression for a writ of error, as in saying that error lies, that a judgment may be reversed on error. It's a Black's Law Dictionary.
So, what you want to say, Mr. Mishra, जदि भी आमे से second line टा को से रखी थांदा, ताले सेटा को blank रही थांदा. कारण ऊपर आंसर टा जेतु no, जदि yes ही थांदा, ताले second line टा fill up ही थांदा. जेतु आंसर टा no, रखी थिले भी blank रही थांदा. तेणु blank बदले से काटी देवा द्वारा किसी गोटे substantial
defect किछि हो.
just error picture tol began देखो error defect or irregularity गोटे category करो right ना
error तो
error पर just error defect or irregularity
section 1
error defect or irregularity in procedure or in law, not in matters of fact.
Error माने defect when technical defect बोले define ହେଇଛି law lexicon technical ता बोले technical defect पाई error is defect बोली पहले then technical defect बोला
पढ़ो
technical TECH technical error लिखा है जी
मैं
technical error as used in the swan song in consideration of the question present in a swan song shall not regard technical error. It means merely abstract or practically harmless errors.
Yes.
Okay.
Technical defect
technical defect is one which may come within the four corners of, but in fact it does not affect the merit of the case. Yes. It's a mistake which does not go to the core of the matter. Okay.
It is not always easy to define what is expression technical defect means. A technical defect in law is one which may come within the four corners of it, but in fact it does not affect the merits of the case. It is a mistake which does not go to the core of the matters.
So what do you mean to say that এটা ରଖିଥିଲେ ବି କିଛି ଲାଭ ହେଇନଥାନ୍ତା ବା ମାନେ କିଛି
କ୍ଷତି ହେଇନଥାନ୍ତା।
କ୍ଷତି ହେଇନଥାନ୍ତା।
ଉପର first sentence ର answer ଟା yes ହେଇଥାନ୍ତା, then second sentence ଟା ରଖିବା ଜରୁରୀ ଥିଲା।
ତେଣୁ ଏଇଟା ଗୋଟେ it cannot be said that ଏଇଟା ଲାଇନ ଯାଉଛି it does not affect the merit of the
case.
Some rules are vital and go to the root of the matter. They cannot be broken.
ବା ଏମିତି କହିହବ ମିଷ୍ଟର that ଏଇଟା କାଟି ଦବା ଦ୍ୱାରା କୌଣସି relevant information voters କୁ to
withheld ହେଲା। ତାପରେ ଆଜ୍ଞା ଅଛି ଯୋଉଟା କାହା କାହା ନମିନେସନରେ ସେଇ ପର୍ଟିକୁଲାର ଏଟା ଉଡ଼ି ଯାଇଛି। ଯୋଉ ଉପରେ ଥାଏ ଯୋଉଟା
ୟା କାମ ସରିଲା ତ?
ହଁ। ତାପରେ ଅଛି ଗୋଟେ ପ୍ରିଣ୍ଟିଂ ଏରର। ସେଟା ଲ ଲେକ୍ସିକନରେ ନାହିଁ।
ଆପଣଙ୍କର ଥିବ କାଳେ ଦେଖନ୍ତୁ, କାରଣ ଟେକ୍ନିକାଲ ଏରର ତ ଏଠି ନଥିଲା, ଆପଣ ପାଇଲେ।
ପ୍ରିଣ୍ଟିଂ ଏରର।
ପ୍ରିଣ୍ଟିଂ ଏରର।
MNOP। PRI printing TI। ପ୍ରିଣ୍ଟିଂ ନାଇଁ ପ୍ରିଣ୍ଟିଂ ଏରର ବୋଲି କିଛି ନାହିଁ, ଖାଲି ପ୍ରିଣ୍ଟିଂ ଅଛି।
ପ୍ରିଣ୍ଟିଂ ଅଛି, ସେ କହୁଛି
ବର୍ତ୍ତମାନ ଆପଣ ଆନେକ୍ସର 11 କୁ ଆସନ୍ତୁ। ଏକ୍ଜିବିଟ୍ 38/3।
ଆନେକ୍ସର
ଆଜ୍ଞା
ସେଟା ଏକ୍ଜିବିଟ୍ 38/3
ଆସୁଛି ପୁରା ଏକ୍ଜିବିଟ୍ 38
357 ନମ୍ବର ପେଜର ପାର୍ଟ 2 ତଳେ ଯୋଉ ଲାଇନଟା ଅଛି
357 ପାର୍ଟ 2 ଲାଇନର ତଳେ ଯୋଉଟା ଅଛି
to be used bracket instruction
by candidate not set up by recognized political party.
This line is missing in all the nomination
papers
exhibited before my lord.
So what I beg to impress upon your lordship is ei line ta nothile a nomination cannot be invalidated on account of this printing error. And these are the things for which the returning officer has been given power under 33(4) proviso to either to ignore or to correct it and accept the nomination.
It is not a substantial difference.
No, Mr. Mishra, ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି କେତେଟା ନୋମିନେସନ ପେପର ରେ ପାର୍ଟ 2 ତଳେ ଏଇଟା ଲେଖା ହେଇନି
ନା
କିନ୍ତୁ
ସେଟା ଟିକେ ଚେକ୍ କରିଦିଅ।
ମୁଁ ଜଷ୍ଟ ଠିକ ଅଛି ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ଆକ୍ସେପ୍ଟ କରୁଛି ଯେ ତ ଏଇ ଯୋଉ ହେଡିଂ ର ଗୁରୁତ୍ୱ ହଉଛି ତାହେଲେ ଯୋଉ କ୍ୟାଣ୍ଡିଡେଟ ଟା ମାନେ ରେକଗ୍ନାଇଜ ପଲିଟିକାଲ ପାର୍ଟିର ନ ହେଇଥିବ ଏଇଟା ତାରି ପାଇଁ ରେଲେଭେଣ୍ଟ ତ ସିଏ ଏଇଟା ଜାଣିବ କେମିତି ଯେ ଏଇଟାକୁ ମତେ ଏଇଟା ମତେ ଫିଲ୍ ଅପ୍ କରିବାକୁ ପଡିବ। ଉପରଟା ଅଛି ଠିକ ଅଛି ଟୁ ବି କ୍ୟାଣ୍ଡିଡେଟ ସେଟ୍ ଅପ୍ ବାଇ ରେକଗ୍ନାଇଜ ଅଛି ସେଟା ସେମାନଙ୍କ ପାଇଁ।
ନାଇଁ ଆମର ସବମିଶନ ଟା ଅଦରୱାଇଜ ଏଇଟା ଯଦି ବି ନଥାଏ ଏଇଟାକୁ ଗୋଟେ ସବଷ୍ଟାନ୍ସିଆଲ ଡିଫେକ୍ଟ ବୋଲି ଧରାଯିବ
କେବଳ ଏଇ ଲାଇନଟା ସେଇଥିପାଇଁ ଯୋଉ କେତେ ଗୁଡାକ
ନମିନେସନ ପେପରରେ ନଥିଲେ ବି ସିଏ ତାକୁ ଷ୍ଟିଲ୍ ଆକ୍ସେପ୍ଟ କରିଛି। ଆମର
ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ କ୍ୟାଣ୍ଡିଡେଟ ଯୋଉମାନେ କଣ୍ଟେଷ୍ଟ କରୁଥିଲେ ବା ନୋମିନେସନ ପେପର ଫାଇଲ କରିଥିଲେ ସେମାନଙ୍କର ପାର୍ଟ 2 ଟା ପୂରଣ କରିବା ଦରକାର ରାଇଟ ତ ସେମାନେ କରିଛନ୍ତି କିନ୍ତୁ ସେଇ ଯୋଉ ଇଏରେ ଏଇ ଲାଇନଟା ଲେଖା alright I followed it. Alright, yes, next.
Then my lord, there are two decisions I would like to place before your lordship. One is from Orissa. Ramesh Raut 2012 1 SCC, page 762.
This is that Ranendra Pratap Swain. Which paragraph are relevant?
खाली ସେତିକି ମୁଁ ଦେଖେଇବି, ସେଇ ଲାଇନଟା ବି ଦେଖେଇବି, ସବୁ ପଢିବିନି। କୋଉ paragraph? ଧରିଯାଉଛନ୍ତି, ଏବେ କ୍ଲୋଜ କରିବା ଆଉ କଣ।
Section 17, which is paragraph 17.
Paragraph 17 ta material, kindly come to page 771. से आगे कोट कर देले section 33. Presentation of nomination paper and requirements of a valid nomination.
Then skip over it and then
4 भी कर ले, 4 रो prohibition तक subsection 4.
ये जो misnomer
Minor.
All right.
से सब सहित करिकरी
18 रो देले scrutiny of nomination पर next paragraph. Scrutiny of nomination बोले. Section 36 तक कोट कर ले. Paragraph 19 रे conduct of election rule 4 तक कोट कर ले. Paragraph 40 ता आती है कौन?
40.
आगे
17, 18, 19, 20 थे conjoint देखिए.
772 paragraph
one used by a candidate set up, who used one not set up by.
Minor.
Provide that there should be 10 electoral pay. 3 one so declaration to be made by giving assignment. First one so is applicable to a candidate.
PI and PII थिला. एबे जोटा CI and CII. ठीक है. Nomination form रे ठीक है बदलिछ.
One so is applicable to one. Okay, with a request to symbol reserve for somebody be allotted to. First one so on the other hand is applicable to candidate not set up by any registered candidate who is contesting the election and independent, recognized political party recognized. Okay. Yes.
Then
paragraph 26, 26.
774. Shall I place?
No, it's all right. I've gone through it.
Mine.
Yes. 24, 25, 26. Yes.
766 number page.
766?
Paragraph 35 रे 80 relevance of the part का लिखो. Paragraph 35 page 776.
Bottom.
छोटा paragraph टा पढ़ो.
The controversy in the present case relates to a candidate set up by a recognized political party of the state, and therefore the relevant form in this regard is Form 2B. Form 2B is in 3 parts. Part 2 is not relevant. A gotai टिके note करो. Part 2 is not relevant and therefore it is not necessary to refer to that. Here also,
that means for a candidate who has been set up by
recognized political
party of the state, this part 2 is nowhere relevant.
Irrelevant. Therefore, deletion of it or
then my lord, part 1 and part 3 is different. Next sentence.
No, I've seen that. These are relevant, yes.
Then the Pune part 3 rajuta.
BI and BII.
The declaration to be made by the candidate giving assent to his nomination. Okay. required to declare this one also.
In para BI, now it is para CI. That I am set up at this election by gas party, which is a recognized national state party in the state, and that the symbol reserved for this above party be allocated to me. Para BI, now it is C double I. Para BII, now it is C double I. Part 3 is applicable to a candidate set up by any registered unrecognized political party or a candidate who is contesting the election as an independent.
ତେଣୁ CI ବା CII is nowhere relevant. ସେତିକି ମୋର ଦେଖିବା।
Similarly, E ତଳକୁ ଯୋଉ ପାରାଗ୍ରାଫ ଜାତି ପାଇଁ ରହିଯାଇଥିଲା, ପାରାଗ୍ରାଫ E ପରେ ଯୋଉ ଗୋଟେ ସପାରା ଥିଲା ଜାତିଟା ଲେଖିବ କାଷ୍ଟ ଟ୍ରାଇବ, ସେଟା ମଧ୍ୟ ଯେହେତୁ ଜେନେରାଲ କନଷ୍ଟିଟ୍ୟୁଏନ୍ସି, that is not applicable, and that is specific instruction in the nomination paper giving asterisk mark, score out this paragraph. Score out means କାଟି ଦିଅନ୍ତୁ.
Next decision is Shambhu Prasad Sharma, 2012, 11 SCC, page 390. The छोटिया decision टा
reference टा आउथरे कहले
2012, 11 SCC, page 390. Shambhu Prasad Sharma versus Charan Das Mohan and others.
Which paragraph, sir?
Yes. Departure from the nomination format.
Every departure from the nomination, se କହିଛନ୍ତି, is not fatal.
Who line टा कौन?
ସେ ସେଇ ଗୋଟା ଦିଅନ୍ତୁ।
Paragraph ଟା ଦେଖନ୍ତୁ ବାସ୍। At page 396.
From the above, it is evident that the form of the nomination paper is not considered sacrosanct. What is to be seen whether there is substantial compliance of the requirement as to the form? Every departure, okay.
Yes.
Every departure from the prescribed format cannot
therefore be made a ground for rejection of the nomination paper. It's stated in clear terms.
paragraph ଟା note କରି ଦେଇଥିଲି ପରେ ଦେଖିଦେବି।
ଦେଖିବା para 18 ଦେଖିଲି
ଅଲଗା paragraph କୁ note କରିଦେବି।
छोटिया decision ଟା whole ପଢିଦେବେ।
Next.
ନାଇଁ ଏତିକି ଆମ
submission ଟା କରିଦେଲା ବସ୍ କରିଦେବ ସେ।
Yes.
Now submission is made in view of the pleadings in the written statement. Evidences, both documentary as well oral, adduced in course of trial, coupled together with the provisions of law prescribed under Constitution of India, RP Act 1951, Indian Evidence Act 1872, and relevant paragraphs in the Handbook of Returning Officer as well as case laws referred to above, the allegations of the election petitioner under paragraph 7A of the election petition stands belied, and the election petitioner has miserably failed to prove and establish his allegations as made under paragraph 7A of his election petition to the effect that the nomination papers filed by the respondent in form 2B are not in prescribed form 2B, and the defect appearing in the nomination paper of the respondent are defects of substantial character for which acceptance of the nomination paper by the returning officer are illegal and improper. With this, I conclude my submission with respect to 7A.
7A. এটা দিল এটা বাহার করো nomination paper টা সেই election petition So 7A is over. Okay. Okay. B relates to that offense.
No, B relates to submission of affidavit dated 3/4 along with the nomination paper on 2/4.
No, 7
B.
7B रे लिखा है respondent respondent has also not filed the affidavit in the prescribed form 26 ता ऊपर ऐसे okay
से कहते 3 तारीख रे affidavit टा
तो पहले prescribed form 26 रे नुहे
नुह
हाँ तार सप्पारे रही से जोड़ा अपन जोड़ा कहउछन जे 3 तारीख रे
affidavit टा 2 तारीख
रे फाइल राइट
सेटा material
कारण
I have to address your lordship
केस होची जे 2 तारीख फाइल कला परे गोटे एफिडेविट से आपन को गोटे जो देइथिले चेकलिस्ट देइथिले से तारी बेसिस रे आपन 4 तारीख रे आनी किनी से जो फर्दर एफिडेविट टा करजंदी जोटा की सोर्न इन हे
3 तारीख रे एफिडेविट करछु 4 तारीख रे हम
एवं
से कहते 3 तारीख रे एफिडेविट टा 2 तारीख रे फाइल हेछ which is no affidavit in the eye of law
right
4 तारीख रे एफिडेविट फाइल कला परे मते आ उटे चेकलिस्ट रिटर्न
देछ
हां राइट दीटा को चेकलिस्ट
दीटा जाको चेकलिस्ट
से कोई चेकलिस्ट देले हां पुणी 4 दिन आ उटे चेकलिस्ट देले रेस्पेक्ट टू ऑल द 4 सेट्स ऑफ नॉमिनेशन
दैट
से माने सेटा को इलेक्शन पिटिशनर एग्जीबिट कर
निजे एग्जीबिट करछन
ओके
विदाउट ऑब्जेक्शन I will come to that after holidays.
This way the matter will never be finished, my lords. Again, after holidays, my lords.
No, 7B. Because Mr. They will also take time. So what is the
Well, there was an assurance
that I was suggesting if I begin, I am to begin on Tuesday. Kalta chutti mo aguru personal difficulty ଅଛି କହିଥିଲି Tuesday, Wednesday, Thursday. Friday is the last.
Friday କଥା
ହବନି ଏଇ 3 ଦିନରେ ଏଟା ସରିବନି
Friday because maybe there may be reference
Monday to be arambha. My lords, the thing is, my lords, he had assured that he'll complete his argument by December. Now, my lords, your lordships is to regulate it. We cannot regulate it, my lords. Your lordship is to regulate it. Because otherwise, my lords, the entire time devoted to this case will become, my lords, frustrated, my lords. That is why, my lords, your lordship.
Not because of us or by the.
No, no, you're going on repeating various things again and again and again, and that is why it is getting elongated.
That is not a single repetition.
No. Yesterday's judgments were all under Order 7 Rule 11. The points that they were arguing have all been answered by your lordships in the Order 7 Rule 11 application, my lords, upheld by the Supreme Court. Again, they are arguing the same thing, my lords. This cannot go on ad nauseum, my lords.
No, that Mr. Kanungo, at that those points have stated after discussing that it may be relevant at the stage of final argument.
But they are saying we have not pleaded material facts when your lordships have categorically held that we have pleaded material facts. And material particulars need not be. Material particulars, my lords, are in the nature of evidence. That is also settled law, my lords.
The problem is that the necessity is
my lords, now on the basis of pleadings,
counsel submits that the matter may be taken up after the Xmas holidays. Mr. Milan Kanungul and senior advocate, also Mr. Ogwal, oppose the submission made by the land senior advocate and submitted that the land counsel for the petitioner is adopting the delay dialing practice and if
by the respondent.
By the respondent and if the case is not, the arguments are not concluded within a specific time limit, it may be difficult for the court to pronounce the judgment within a reasonable period. बाकी तो उनका डाकी दी तापर मुंडा कुछ लगे as agreed upon between the parties, take down as agreed upon between the parties, है ना? The matter will be taken up on ये टा January मासा calendar कहीं this matter will be taken up on 2nd itself. On 2nd January 2024, 2nd January 2024, the learned counsel for the respondent shall close his argument by 12th of January 2020.
10th because Mr. Agarwal has some personal difficulties. So 10th.
सेटा गोटे सप्ताह एंड आसुची 12 सेतपई मु रख दोची आपण स्टार्ट करिवे नै 15 तारिख ता बोधे छुट्टी अछि मकर संक्रांति पई सो इट विल बी यू विल स्टार्ट योर आर्गुमेंट ऑन 16 सो 16 आपण केते दिन कहि दियो
सेटा कहउछन 5 दिन रे करते
I have a personal problem. I will be out of town from 10 days, my lord. I will be out of town for 10 days, my lord, from 22nd to 31st, my lord. So let my senior complete as suggested by my senior that he will complete by 10 so that I can complete by 22nd.
Okay.
Well, 22nd evening I have to leave, my lord.
10th January, then the learned counsel for the election petitioner shall conclude the argument by 22nd of January 2024 and the reply shall be given by the learned counsel for the respondent by 31st of January 2024. ठीक है?
बस.
Okay. हाँ? हाँ. The file be kept before the learned registered judiciary in the meantime. In sealed cover कर दूँ. Yes.
Next date is fixed to 2nd.
2 तारीख January 2024 रे आपण आर्गुमेंट आरंभ करिवे 10 तारीख सारिवे सी 11 तारीख रु धरिवे प्रत्येक दिन रहिबो केस हैला तणो बाकी केस आर्गुमेंट सरिबो 31st रे I will prepare the judgment by the end of either February or maybe first week of March 2024.
ठीक है हमें जो 3 टार बसुचे ठीक है 2.5 टार कर
then दुईटा रू मु कर दोछु हला दुईटा रू कर दोछि
हां दुईटा रू कर
मु लिखि देबी नोटिस रे जे आफ्टर दिस इज ओवर द अदर मैटर्स विल बी टेकन अप
सर इन फैक्ट जदी एटा सॉरी जीवो आपन को देन फुल फ्लेजेडली अदर मैटर्स भी आपन नै पारे एटा हमर सॉरी गले
ना ऑब्वियसली दैट
जनवरी मासटे खाली आपन डिवोट करे
ठीक है ठीक ओके सो एटा को टाइम दे दियंतु 2 तारिख दिन 2टा बेले ओके क्लियर 2 रु 10
2 तारिख ऑनवर्ड सब बेले 2टा बेले ने
हां 11 रु होची 22 पर्यंत तांकर इलेक्शन पिटिशनर रिप्लाई होची अप टू 31st ऑफ जनवरी 2024 ठीक है बाकी जोडा को ताकि डाकी देइसली तम से तम कहि दे ए जो जजमेंट गुडा